I can do what I want when I want to do it. I can do what I need when I need to get through it. When I need someone else, can't be too proud for help, but gotta look after myself. Sometimes it can get lonely, never living in the moment. When the sun is shining, hope that I'm reminded, like how the clouds keep changing. I'm always steady rearranging, going back to the basics of what a good day is. What a good day is. And that's exactly what the day is. But it's exactly what you make it. So please don't go wasting. And I'll do the same, even if it's raining. How could I complain? And my feels got me feeling some type of way. You always free to take a break. Hope you feel what I felt. You gotta look after yourself. Sometimes it can get lonely, never living in the moment. When the sun is shining, hope that I'm reminded, like how the clouds keep changing. I'm always steady rearranging, going back to the basics
All right, y'all.
of what a good day is.
It is that time. You know what to do. Drop a 1 in the chat if you can hear me. Drop a 1 in the chat if you can see me. It is a beautiful day. And shout out to Keely for kicking off the show the right way in here. Thank you to everybody who's dropping the 1s in the chat. Let's see how we're looking though. Are we? Oh yeah. Looking all crispy and clean on the screen. Welcome y'all. Welcome back to another YouTube live stream and another episode of the Music Morning Show. I'm your host ClassE Beats of ClassEbeats.com. And this morning we're going to get back into more YSL trial coverage. We had some crazy things go down yesterday afternoon. Shocker, right? We're going to get into it here in a second. And also we do have some more court proceedings today. We may get a directed verdict motion in there as well. So Judge Whitaker is going to cover that. I actually haven't seen Law and Crime, 11 Alive, or Fox 5 actually put their live stream up today. So it'll be interesting to see what happens there. Either way, let me say good morning to the people. Of course, early this morning, the awesome, amazing Amy is in here. Always good to see you. Thank you for everything you do. We got Les Cleaver in the building. My guy, 904 Cowboy. Anton's in here. FS, Transporter. Let me put some respect on and read your whole thing. Transporter A842. Deborah Lewis. We got Varman in here. Kay, Elaine, Krista, Mr. Frieza is in the building. Good to see you. Valencia's in here. We've got Alabama, Gigi, Rachel. Oh my gosh. JB Brown, my guy. Krisha, Christine, Bonnie, Gerald, Michelle, Sabrina, BG. Good to see y'all, man. Good morning. Shout out to Michelle, Carrie. Mary is in here. Underdog Boxing. Lauren Robinson's in the building. Wendell is in here too. Good to see y'all. I'll be saying good morning as we go throughout the show. I do have a huge favor to ask you all, and it's a big deal. If you could, please make sure you like the video on your way in. I'm going to continue to beg for likes my entire YouTube career. Not only is it free, not only does it help the show continue to grow, but it lets the YouTube algorithm know that you guys are enjoying the show and it shares it with more people. So if you could take 2 seconds to do that, I would really appreciate it. We're actually going to do a little bit of a rewind this morning. So we're going to go backwards and go back to yesterday afternoon. A couple of things went down. We got to hear some interesting commentary and cross-examination, or recross, I should say, from the defense. And Doug Weinstein was trying to get detective investigator hybrid super stalker Viverito's testimony thrown out. He was not feeling it. So we're going to check it out and see what happened. If y'all saw this, I appreciate you sticking around. And then once trial starts, we'll give ourselves a little bit of a delay today, and then we'll go right to the live trial. But I wanted to see what happened here because I heard what went down yesterday afternoon. I haven't seen it myself, so we'll all react to it together. And if you've already seen it, that's totally fine as well. I'm sure you guys won't mind a little bit of a rewind as well. Yeah, this is crazy. Here we go.
I don't know what the.
Let me get the volume right for y'all.
I'll tell you why he objected. I had already asked the witness the question about the 90 miles per hour. So that question was done. My next question, I asked her to read the location of PJV2. That's it, what was on the spreadsheet. Then that is when Mr. Shard objected. So that is the objection that's on the floor. At this point, I've asked her to read PJV2.
Well, she is reading off of an ankle monitor report from the ankle monitor company. To the extent that she reads off of it, that's not really my issue. It's when she starts to interpret the data.
She loves giving her opinion.
She doesn't work for that company. I don't know, for instance, the PGV2, whatever, PJV2, I don't expect to hear her testify or what that means, because she's not the ankle monitor person. The ankle monitor person would have been the person to ask about those things. So I don't get.
And what is VJV2 say?
So the next thing that I was going to show her, which was already admitted, is the picture of PJV2, which is a location that's already in evidence.
But how does she? Okay, so
What you were going to ask her to read?
Yes.
So again, you got detective expert Viverito talking about things she's not even an expert on. Is she an expert on anything? Expert on Instagram and talking to hood dudes. I mean, I guess that's something. I think my battery's dying. Is that what it takes to become an expert? Just be in the streets, but don't commit any crimes and be good at navigating social media. Think about it, y'all.
So this is the spreadsheet, Your Honor.
Okay.
On here, which I had her read earlier on the spreadsheet, the column has the name,
I love
column
burritos
D
too,
has the
Terry.
date and time, column E and F is longitude and latitude, and column G is a location. So before the objection, I believe she was reading, or she had read, at March 14th, 2022
What's
at
up, Empress
10:02
Fox?
p.m., the location PJV2 plus VR, Atlanta, Georgia. That is what my question entailed. And that was the
Okay, and
objection.
she read that?
She
Or
read-
is- Okay, she read PJV2 plus VR, Atlanta, Georgia?
I believe that. if
Or
the
is that
objection-
when the objection came?
That might have been when the objection came.
Okay, and then what?
And I was just going to have her read the date and time of that location. Then I was going to show her what has been admitted already as already admitted as 397 VVF.
That plots that location?
Correct.
Oh, and while we're here, shout out to Empress Fox is in the building. I got to stop the show for a second. And I want to read this. Empress Fox, I wish I could bring you up on the show. But shout out to Empress Fox. Y'all may know her for a lot of the work she's been doing with protests and just creating awareness about what's going on during this YSL trial. Thank you for being here. She is actually posted this on X not too long ago, and I'm going to read it while I've got her in the building. She says, for immediate release, community rallies against injustice, protests to address dire conditions at the Fulton County Jail. We talked about that in length over the weekend and last week on this channel, and challenge the use of rap lyrics as evidence in the YSL RICO trial. Atlanta, Georgia, November 19th. Concerned citizens will gather for a peaceful protest on Thursday, November 21st, which is tomorrow, to address two pressing issues within the Fulton County justice system: The Department of Justice's recent findings of inhumane and unconstitutional conditions at the Fulton County Jail, and the controversial use of rap lyrics as evidence in the ongoing YSL RICO trial. Protest schedule from 9 a.m. to 12 p.m. Fulton County Courthouse, 136 Pryor Street, Southwest. This demonstration will commence with a prayer circle and focus on the implications of using artistic expression as criminal evidence, referencing the Restoring Artistic Protection Act of 2023, the RAPT Act, and its potential impact on the First Amendment rights. From 1 to 3 tomorrow, Fulton County Jail, they'll be at 901 Rice Street. Better get ready, they're coming. This protest will address the grave concerns outlined in the Department of Justice's 97-page report, which we went through a lot of it, which details systemic issues within the jail, including allegations of violence, excessive force, inadequate health care, and the discriminatory use of restrictive housing. We are deeply troubled by the Department of Justice's findings and what they reveal about the state of Fulton County Jail. State's protest organizer, Ten Wilkerson. Furthermore, the introduction of rap lyrics as evidence in the YSL trial raises serious questions about the fairness and integrity of our legal proceedings. We are calling for immediate action and accountability from the Fulton County officials. The key issues they'll address: inhumane jail conditions. The Department of Justice report cites a pattern of neglect and abuse within the Fulton County Jail, with concerns including overcrowding, violence, unsanitary conditions, and lack of access to essential medical and mental health services. And we even read in that Department of Justice report, there were people who got in there, 7 of them, who got in there, and within 24 hours, they were gone. Sad. So sad. Questionable legal practices. The use of rap lyrics as evidence in the YSL trial raises concerns about freedom of expression, the presumption of innocence, and the potential for biased interpretations of artistic works. Demand for accountability. Protesters demand transparency and accountability from Fulton County officials and urge them to take immediate action to address the Department of Justice's findings and ensure the protection of inmates' constitutional rights. All right, and they are going to be there again tomorrow, Thursday, 9 a.m. to 3 p.m. Shout out to Empress Fox. Thank you for stopping by. Thank you for all the work that you're doing out there, spreading awareness. We're going to continue to do the work here as well. And if y'all missed, for whatever reason, those videos where we went through when we actually broke down what was happening inside of Rice Street specifically, make sure that you go back and check those out. And if you can get down there to the protest tomorrow, make sure you do that as well. I know Empress Fox will be there too. And thank you. Yeah. Thank you for being here, Empress Fox. I'm glad you stopped by. I saw this earlier and I almost, let me repost this too. I almost completely forgot to read it. So thank you. All right, let's go ahead and get back into the coverage, get back into the rewind.
By the ankle monitor company? Or by whom?
We showed the ankle monitor company that picture as it correlated to this location here. So we printed out Google images of these locations, PJV2, 464 Windsor, which is what I just showed her previously.
By the latitude and longitude?
Yes.
Somebody plotted latitude and longitude
I don't.
on a map
No, we
to get
pulled
that
up-
location?
No. We pulled up the map. We went into Google and we put PJV2 plus VR. We just Googled it. And we pulled up the location.
So essentially, they want someone who doesn't work for the ankle monitor. And mind you, the ankle monitor company person is already here. They want someone who doesn't work for the ankle monitor company to take something that's on the ankle monitor company's Excel sheet and then compare it to a Google printout that the prosecutors
You're right.
printed out, and
That
She's a
is already
Google
in
expert.
evidence?
that's
You're right.
already in
It's in evidence. It's not. We're not admitting it through her. It's in evidence.
Such
the
BS,
ankle
man.
monitor witness introduced it. He
Okay.
introduced it along with the record of the pictures. And so
Okay.
at this point, when Mr. Shard has
Okay, and
challenged.
then what? So you'll then say, and here's this other piece of evidence that is a plot of PJV2 plus VR.
Is that the location at the light that for the surveillance video that we just observed? Because
Okay.
all of this is in this is all in response to Mr. Shard's cross-examination about what occurred at the light.
Can you put that back up again, please? The thing that was just up. And from this, you are going to have her extrapolate that because at 10:02, his ankle monitor showed him at that location, then what? Because you came up here and were saying this is going to be able to show that the timeline is accurate across all the different devices. How is it going to do
So
that?
the challenge that Mr. Shard made is that
Answer the question.
the 9:59 phone call. This started with the phone call at 9:59, which is the wiretap phone call. Mr. Shard asked Investigator Viverito, are you able to know if that is the accurate time? Because of that line of cross-examination, we are now showing Investigator Viverito other admitted evidence that shows a correlation to that 59 time. So when you look at this chart, before we get to the 10:02, which is at PJV2, at 9:59, the
Please
ankle.
put that exhibit back up.
The spreadsheet.
Prosecution on that BS again.
Or hand it to me. I'm happy to have a paper copy of it. So now we're talking about 9:59 and not 10:02.
Your Honor, we're showing Mr. Shard started off at 9:59. Then, if you can recall, he went through the entirety of the surveillance video at the FedEx. So that's after 9:59. So what we are showing is other evidence that
He does not dispute that he was at the light
he disputes.
at the
exactly
same
what we're
time
saying.
as Mr. Drinks was.
Your Honor, he disputes that Mr. Stillwell is the person who was shooting. He disputes that
This doesn't prove
the
that,
call
though.
at
This is
9:59
crazy.
was a call to get on FaceTime to shoot Mr. Drinks. We are saying that call, that FaceTime call, is a call where they said we are getting ready to go shoot the ops. That's why they get on FaceTime. So he is challenging all of that, Your Honor. So what we are showing is at 9:59, if you look here on the ankle monitor, he's at 464 Windsor Street. That is the BP gas station. He then
If
a
the
minute
9:59 is accurate.
Here's
And lined up to, I mean, I don't see how you can establish that 9:59, according to the ankle monitor company, is, spot on to the second.
Henry needs to be sitting in
9:59,
court.
according to the wiretap.
But we're saying that it's accurate time, Your Honor, because he wants.
But this doesn't show that, though. That's the problem we have here. And if the times aren't synced up, then what are we even doing?
He's at 464 Windsor, which is where, if you look at the BP gas station video footage, that is when all the cars begin to pull off from the surveillance video at the BP gas station.
But there is no cross-reference to the wiretap, which is the point.
But
That's my only point,
but
is
that's-
9:59 on the wiretap. We don't know when it is on the rest of these devices, and this information
you,
does
Tanya.
not
It's
give
not
us
illegal to
through
speed
other
off, though.
surveillance systems.
Agreed.
And
Do
this-
you have him on the video at the BP station talking on the phone and going like this?
We have the wiretap that has him,
Nope.
we believe, the phone plot.
I know you believe it. Do you have evidence to establish it?
Our evidence is
that-
circumstantial evidence that he is at the gas station. Do we have direct evidence? No, Your
No,
Honor.
do you have evidence that the 9:59 that you want is the same 9:59 on all of the different things that recorded time in video?
That is why we're showing this, Your Honor, because we're trying to show circumstantially that all these times are.
How
together.
are you showing circumstantially that it lines up?
Your Honor, because when we look at the ankle monitor
don't know.
information, he is at the 464 Windsor at 9:59. The call comes in at 9:59. The BP gas station surveillance video has 9:59. So we are showing that all of these things coexist. So the time could not just be off because all of the times are at approximately 9.
That's if he got the call when he was still at the gas station.
Which they can't prove.
Your Honor,
The fact that they all at some point say 9:59 doesn't establish anything if you don't have a video that shows him talking on the phone at 9:59 so that you can go, aha, see, the video lines up with the ankle monitor that says 464 Windsor Street. Otherwise, it's
Right, and so what we have ultimately is that there is no evidence, none.
Also, Judge Whitaker needs to chill. I don't know why she started yelling and getting frustrated. Like, let's relax. We're professionals here, right? Jesus.
just what you wanted
Chill.
to say, but it doesn't actually, even circumstantially,
she's getting
establish
so
that.
excited.
You can argue it, but you can't have a witness say, yep, this
Raising
says
my blood
9:59,
pressure.
so that means
but we
that's
didn't
when
ask
that.
her to say that, Your Honor. We never asked Investigator
But-
Viverito to
but-
say that. We asked
I
her
know,
what
but
time
you were telling me that's what you were
No,
leading up to having her say.
No, it's not, Your Honor. What I said I would never have her say, is he exactly on the phone at that time?
Just
Because
sounded
he's in a
desperation.
tinted car, so we don't know. What we know is from the wiretap that at 9:59 there's a phone call. That's what we know.
That
I
at
can never-
9:59, according to however the wiretap clock was running.
Correct. Your Honor.
Yes,
So
that's
in
what
nobody
come out.
disputes that.
Your Honor, we've stopped talking about
Ms. Hilton, you
9:59.
came up here and
Doesn't make any
said, I'm
sense.
asking these questions so that I can establish that the timeline lines up for everything.
Yes, Your Honor, the timeline lines up. So
Okay.
at this point, I can show that all of these different devices are around approximately the same time.
I don't think anybody disputes even that it's approximately the same time.
Mr. Shard does. Okay.
You can
Judge
have
Whitaker
her, it's in evidence. You can have her
Oh,
read
man.
something, but you cannot have her say, yeah, that means all of these times lined up. Or
I
that
never was
means
gonna have-
9:59 here and 9:59 on the wiretap were the same thing.
We never had her. We were finished with the 9:59, Your Honor. The only thing I had just asked her was about PJV2 when he objected. Well, we were finished with 9:59 about 5 questions ago. So the only thing that Mr. Shard objected to at this time was that she was reading PJV2.
No,
That's
that
what the
she
objection-
was about to interpret.
She was not, and that's the thing. That
Okay,
was,
well, great. She's not going to.
Okay,
but,
well,
and that wasn't the state's intention.
I
Okay,
don't
then I have
know.
no idea why you think any of this is going to establish that all of the times lined up, but
Lord.
I'm going to object on relevance grounds at this point because I don't know where we're going, but it seems that they were trying to establish something. They said they're done establishing that, and Investigator Viverito is still interpreting ankle monitor data. So I'm going to object to relevance in 403.
Your Honor, as I stated earlier, Mr. Shard has challenged what occurred at the light.
I
His-
know.
She's done.
I know.
So at this point, we're just showing,
God help me.
based on admitted evidence, what occurred at the light, Your Honor. That's all.
Why?
Can I ask a
That
question?
doesn't show
Why
it. That
is
doesn't show
improper,
that.
Not relevant. So if there has
Oh,
been
body, sit
questions
down,
and
man. Come
testimony
on.
About whether the times for everything sync up, I think has been Mr. Sharp's his argument the entire time. Well, in the screenshot that was admitted to Detective Hogan, and
Okay, I didn't rule that it wasn't relevant. What we discussed up here at the bench was that it's not within the scope of redirect, which is when Ms. Hilton said, oh, yes, it is, because I'm going to be establishing that all of the times line up.
on cross, he disputed that the 959 from wiretap was anywhere close or could be related to the 959 anywhere else.
Was established as
Let it go,
being the
Bobby.
same 959, and I have heard nothing that, maybe you could tell me how you can establish that.
So at 9:59, when he makes the FaceTime or the call, he is at 464 Windsor Street. Okay, so then you go to your next step.
No, that is, how do we know that he's at 464 Windsor Street?
Says it.
Because some other item of evidence says it, and we don't know that they're all running on the same clock.
That's what we're trying to show you it is, because at 9:59 on the, well, if everyone would just wait and we'll get to the big ta-da. So at 9:59 on the wiretap thing, it says 464 Windsor Street. On the ankle monitor, on a separate device, at 9:59, Mr. Jackson is at 464 Windsor Street. That correlates. They're the exact same place at the exact same time. At 10:02, it shows that he's at PJVR2, whatever. That's the intersection of I-20 and the light. And then at 10:02, on the FedEx thing, and it says 10:02:17. So it's the exact same thing. It's to show that all the times line up. All this questioning that the times are not accurate, that the times don't sync up. We're proving that they actually do sync up, which is what he challenged Investigator Viverito about this 9:59, and she's just making it up, and all the evidence is being presented as how she wants it to. And now we have physical evidence from different videos that show they actually all do sync up, that they're all running on the same, time width or band or whatever.
I think you can argue that. I don't think that is established. But if you want to have her say, but Ms. Hilton says you've already left 9:59 anyway. So I'm still at a loss as to where we are. But we'll just get her back in. And
That's all of us, Judge Whitaker.
You bring her back in because, unfortunately, it's my job to further tax the patients in the court.
what's that?
Uh-oh.
Yeah, I have a motion to strike the testimony of Investigator Viverito as well as any evidence that came under her. And the reason I make this motion, Your Honor, is yesterday it came up that she had not been, that she had been following the case. The court asked me to not pursue that. I'm not.
Come up that she had been following the case. It came up that she knew that somebody had mentioned her on Twitter.
Okay, and your opinion would have been different if she was following the case? Because
No, if you know that she was following the case, that doesn't exclude her as a witness. You can let the jury know that.
Okay, because
You can ask her that.
I can ask her about her following the case?
Sure, and we'll see what she says.
Okay.
And if that's so, then it still doesn't exclude her testimony. It just lets the jury know, well, she may know some of this other stuff from listening to some other witness.
Okay, because what I would like to get into, and we may as well bring it up now before the jury is here, is that she got into an altercation out in the hallway with Kayla Bumpus.
Why is that relevant to the guilt or innocence?
I'm about to go there, Your Honor.
Okay.
Just
Yo,
let me
this is
finish
wild.
a second.
This is
She got
crazy.
into it because she was watching Kayla Bumpus's YouTube feed about this case. And Kayla Bumpus apparently called her.
Okay, you may get into whether she has been tracking this case.
Mm-hmm.
You may not get into whether she got into a dispute with somebody about their posts.
It gets into her bias against these defendants, Your Honor. It goes directly to it.
Judge Whitaker is
What are
done.
what are you proposing to ask?
I'm proposing to ask if she told Kayla Bumpus in the hallway that was the last time she was going to call her a hoe. It goes direct.
I'm
Look at
sorry, the
Max.
last time who was going
That
to call?
Kayla, sorry for the pronouns, that Kayla Bumpus was going to call Investigator Viverito
We need to
a
get
hoe.
into who it was, or just that somebody.
Yes,
I think we need to get into who
Why?
it was.
we have to. Oh
Why?
my gosh.
Because she's married to Mr. Jackson.
Well, was she at the time?
So it's true. Oh my gosh. Congratulations to the new couple. Hey, yo. It's true. I didn't even want to bring this up. And I know there had been rumors going around, but they said it in court. Mr. Abadi, I guess, did his research. It's official. Shannon Jackson, Stillwell, and Kayla Bumpus are married. Wow.
Time. Is this for real, y'all?
She said,
Yeah,
"Is this for real?"
Well, it does.
None of this is
with
relevant.
you,
Whatever
Judge
is
Whitaker.
happening between Ms. Bumpus, Mr. Jackson, has nothing to do with the guilt or innocence.
If she-
Unfortunately, the bias of a witness, well, fortunately, or I strike that. It is not fortunate or unfortunate, except for the fact that it is dragging this case on even longer. But a witness's bias towards a party may always be shown.
If she is in a dispute, if she's
Don't
in,
talk at the same time.
Caleb Bumpus is not a party to this incident. Caleb.
Yes, but if she's married to one of the parties, then
Look at Max.
that might qualify.
If I
This is a clown show.
I don't know. I'm not the proponent of this evidence. I'm hearing Mr. Weinstein out, but
Hey, y'all spam free Mr. Bumpus in the chat. Can y'all spam free Mr. Bumpus in the chat? This is insane. Absolutely insane. Wow.
my silence should not be viewed as acquiescence that I believe this should be admitted. I need to hear what Mr. Weinstein's saying because I may have an objection myself.
What I'm saying is that if there is a relationship between Ms. Bumpus and the defendant, then Investigator Viverito's bias against that.
Against being called a bad name?
No. If she is in an altercation with someone that's in a relationship with the defendant, I think, and especially if it is a threat, because
How is that a threat?
that's the last time you're going to call me a hoe. I mean, I've had clients arrested for less.
You may ask.
Thank you, Your Honor.
No, I'm not finished with my sentence. You may ask if she is following the case and has been following the case in any kind of manner. But it's really only relevant if she listened to the testimony of a witness. So
Free
you could
Mr.
ask
Bumpers,
that.
man.
But if she's just looking at, and I don't even know if she was looking at, maybe somebody told her. So why don't we get her in here and find all of that out outside the presence of the jury before we go into something that ends up being a bunch of nothing?
Well, that's why I wanted to bring it up when the jury wasn't here, Your Honor.
So can we also bring up before we go into the side circus the fact that
Mr. Abadi says side circus. What? Hey, yo, chill. Relax, Mr. Abadi. You want to see a side circus? Talk to your coworker.
Yeah, I mean, I don't think saying who this is before we find out anything. I mean, do we know whether, we don't even know whether
Messy.
she's actually married to him or if she was married to him at the time or if Miss Viverito knows that or if it was because of any kind of bias against Mr. Stillwell
Now, Kayla got her
or
chance to
just
testify
that she
and
doesn't like being called
fumbled,
that
so
name.
she
Well,
needs
and
to
no
stay
one
off the
would, Your
stand.
Honor, obviously. But if she is in an altercation with someone in a relationship.
What do you mean by altercation?
A verbal altercation.
Okay. I mean,
You know,
a
if there's-
verbal, that's
if
the
there- I
last
don't-
time you're going to call me that?
Excuse me, I'm
Yeah,
sorry.
That's the
a
last
threat.
time you're going to call me that? That's not exactly an altercation. Is that,
Okay.
is that all you've got?
That's all I have.
Okay. That's it. I think that this is 403 material.
There we go. One mistake.
Judge Whitaker
Hoisted
is
on my own
objecting
petard, Your
403.
Honor.
Correct. All
That's
right.
funny.
Let's get the.
If y'all want to see what happened, I decided to get messy today and I went and I did some digging. Shout out to Nosy Wren for posting this from I guess. This is crazy. Anyway, what does Nosy Wren say? Well, if you wanted to know what happened with Viverito and Kayla, Tasha was live. Here's what happened.
She confronted you like that?
Yes. I said, bitch, hoe, all that.
I'm like, what the hell? Well, you can't need me because I can't. I'm not going.
Ooh, wait till I get on YouTube.
Wait a minute. Wait a minute. Rerun. Come on, slow down. Turn around and tell me what happened again.
Why I gotta always be the bystander?
Okay, what happened again? Tell me what happened.
I'm literally just standing there.
Hold up, y'all. Let me see what
I'm
going on.
looking at her, not doing nothing.
Not paying her no attention.
We have no conversation. We talk about jury instructions, you know. She get off the elevator, Simone, Christian, all that. They walking down on their little thing.
They walking back in?
No, and she say, hey. I said, I wish I would speak good. She said, and you got one more time to call me a hoe.
Like she got bogged down.
All of it. Now, what you gonna do?
Wait a minute. She waited till they got on the elevator. They were coming off the elevator.
It was in the middle of the courthouse.
Crazy.
No, that ain't professional.
It's a threat.
Oh my God.
But I'm still.
All right. So
She
There it goes. Anyway, let's get into the live court proceedings. That's enough messiness for today. Actually, let me rewind this. I'm gonna read some of these super chats and then we'll get into it. Shout out to y'all for dealing with the messiness. Oh my God. This trial is insane. Yeah, for real. I want to be in the movie though. I hope they let me in the movie. Shout out to all the super chats in here. Shout out to my guy Gerard dropping the 2-bomb. We had Gina in there with the 249. Says good afternoon, love from Ireland. Thank you for being here. Also shout out to Teflon Don, says Tiffany Hinyard needs to be sitting in that court. Tiffany Hinyard has her own issues. She does not need to be anywhere near this YSL trial. And then also Teflon Don with the 2-bomb says Kamala trained her well with the word salad. Yeah, the word salad is strong with Miss Hilton as well. And then, oh, I don't know why it didn't show up, but shout out to Amy and Amber in the building with the 50 bomb says, if Queen of Body don't yo, let him live, Amy. Dang. Also, Amy gifted not 5 memberships, but 10 memberships. All right, so if you got a membership from Amy, make sure you say thank you. Shout out to Amy and Amber for the major love and support. All right, we're gonna get into this live court proceedings, and if we end up having an extra long break, we'll go back to yesterday afternoon because I wanted to see the rest of Recross. Shout out to Amy, always showing love. Here we go. Oh man. All right, G-Roll, you're getting on my nerves. Get out of here.
Good morning, Your Honor.
Good morning.
This is wild.
Let me begin just by stating that
and shout out to Henry Resilient too. My
Mr.
dog is in
Sharp
the building.
and I last night went through a number of the predicate acts and overt acts that are in the indictment, and we've kind of made a detailed list of those predicate acts that we do not believe have been presented at trial.
Okay.
And I'm going to let Mr. Sharp speak to that when he makes his motion orally this morning. I join in all of those that he does. And we are moving for a directed verdict on each of the counts against Mr. Kendrick, counts 1, 2, 50, and 57 through 63. And I'll go through each of those in order.
All right.
We're also moving for a directed verdict as to those overt acts that are before the 5-year date, before May 10th of 2017 in the indictment. Based on where we're looking at the jury instructions and the law, my understanding is that the jury is going to have to find at least one overt act that occurred after May 10th of 2017.
Right.
So I believe it would just be extra work for the jury and potential confusion if they were to sit there and go through each of the overt acts before May 10th, 2017. I understand that the state is allowed to put those into the indictment for a number of reasons. I understand that they like them in, or they want them in there in order to be able to quote unquote tell the whole story of the alleged racketeering activity. But since none of those overt acts can be used to support the any racketeering conviction, I don't believe that those overt acts prior to May 10th, 2017 should be before the jury for a decision. As to, just turning to the details of the different counts, as to count 1, Your Honor, the RICO count, in that situation, in that count, I don't believe the state has shown evidence upon which a rational trier of fact could find an overarching conspiracy seeking to achieve an overall common goal as required by the law. The state has shown a number quite a few, I would agree, a number of individual acts they've presented. They have presented a number of crimes and alleged crimes committed by co-conspirators. But I do not believe that they have presented to this jury any form of an overarching conspiracy that would tie those acts together. The second part, I don't believe that the state has presented to the jury an enterprise that would be required, at least a criminal enterprise. I do appreciate that perhaps they don't have to show that the enterprise was criminal in nature. So I'm not going to spend a lot of time on that. I don't want to take up the court's time. I have some things in my written motion. Third, a pattern of racketeering activity is required for the RICO. This pattern, as you know, requires two predicate acts. They have to be within 4 years of each other. And the key that I want to focus on is that these acts have to be interrelated. And it's the interrelated portion of the statute that the state has not shown for the jury, and that a rational trier of fact could not find. Again, after watching this trial for a year, it's clear that the state has put on evidence of various crimes and alleged crimes. They've put on witnesses. They've had testimony from individuals that are alleged members of this conspiracy that have taken the stand and admitted to committing particular crimes. But they haven't shown at all that these crimes are interrelated. In fact, when the witnesses have taken the stand and they've been questioned, in response to questioning, they've stated, I would say universally, I mean, it's been a year, so I don't know that I have everything in my head, but I believe they've stated universally that they committed these crimes for themselves. If they sold drugs at a gas station, it was to get money for themselves. If they robbed somebody, it was to get money for themselves. There's been no demonstration that this was interrelated at all. There's been no demonstration, for example, of money flowing up and down the organization, and they could have attempted to show that. They could have subpoenaed financial records. They didn't do any of that. It's as if the state believes if they just show a tremendous number, and I guess we have close to 200 acts, if they just show a tremendous number of different acts, that's sufficient. And it simply is not sufficient. They can try to argue interrelatedness, and I am sure that they will, but they haven't demonstrated that for the jury such that a rational trier of fact could find the interrelatedness that's required for those predicate acts. Regarding count 2, the murder of Donovan Thomas, again, it's been a year. I could be leaving things out, but from when I have looked over the evidence that's been presented in this court, what I have seen them present, the state present, is Mr. Kendrick at a Texaco station inside of a Pontiac. And inside of the Texaco station, this Texaco station is a block from the location of the murder of Mr. Thomas. And they show Mr. Kendrick in and out of the Pontiac. They show him in a conversation with someone that may be in an Infiniti. But when Mr. Kendrick leaves the gas station, he's in a Pontiac. There's been no testimony at all, nothing, no video, no evidence that Mr. Kendrick somehow moves from the Pontiac into the Infiniti. And the Infiniti is what is alleged to have done the drive-by shooting of Donovan Thomas. There's been testimony from the state's own witnesses. I believe they presented an Infiniti identification expert that was able to identify the car that goes by as an Infiniti. It is not a Pontiac. Mr. Kendrick is not in anything other than a Pontiac. What else is the state presented? They have interviews that various individuals gave with law enforcement. I believe they have interviews that they've presented in the form of video of Kenneth Copeland on June the 10th, 2015, speaking with law enforcement. They have interviewed, they have the plea agreement from Mr. Sledge And by the way, that plea agreement from Mr. Sledge does not identify Mr. Kendrick specifically. And they also have Mr. Zachary's interview with Detective Thorpe. But in the case with each of those witnesses, when they've gotten on the stand, and the Sledge one is less important, I'm not going to focus on that. But Mr. Copeland, and Your Honor saw this, repeatedly told the jury that he lied to the police. He said anything he needed to say to avoid putting on that blue jumpsuit that Mr. Shart so desperately wants to bring into the court and show to the jury. He would finesse the police. He would tell the police what they wanted to hear. He would sprinkle grains of truth into his stories to lend them credibility with the police officers. But when he took the stand, he completely renounced everything that he said previously. Mr. Sledge, as you well know, also renounced much of what was in his plea agreement, although, again, that plea agreement does not focus or even, I believe, mention Mr. Kendrick. And then again, Mr. Zachary renounces what he says on the stand. So I think that a rational trier of fact could not find that Mr. Kendrick had any involvement in the murder of Donovan Thomas. Last, Your Honor, counts 57 through 63. All of those counts relate to the activity, the raid on Jeffrey Williams' house on May 9th, 2022. Each of those counts is either specifically gun or a gun count or a drug count, or they're predicated on a gun count or a drug count. There has been zero evidence of Mr. Kendrick in possession, in actual possession of those guns or drugs. I'm sure the state will argue that he was in constructive possession. And I guess and I'm assuming they're going to argue this because they have two pictures from Mr. Kendrick's phone that were on his phone, that were modified on his phone on May the 9th of 2022. There's been no testimony presented that those pictures were taken by Mr. Kendrick. The only evidence that has been presented is that those pictures are of the inside of the house. So, but let's assume he's inside the house, even if you want to make that assumption. There's been no evidence of constructive possession because there's been no evidence presented of any intent or ability or intent of Mr. Kendrick to exercise control of either the drugs or guns in that house. Zero on intent and zero on his ability to access those weapons and drugs. Last, Your Honor, with respect to count 63 is the 133 charge against Mr. Kendrick. As we discussed previously in court, there is an essential element of 133 that has been left out. So I believe a directed verdict on 133 would be, on that count would be appropriate.
Let me interject and ask you, I saw that Mr. Abadi had sent something that addressed whether, even if directed verdict is appropriate on that, a lesser included. Can you address that?
Sure. I saw the one specific case that I saw that would support Mr. Abadi's position was Martinez v. State, 318 Georgia Appeals 254. And that case, from the limited time I had to review it and do further research, does appear to support Mr. Abadi's position regarding 131 being chargeable. But that case, I cannot find a single other case that follows that case. I also, just again to be candid with the court, I don't see any case that says that case is wrong. But I would argue that the 131 count should not be charged to the jury, if for no other reason than the state puts that 133 charge. Well, I don't know what the state's motives are, but I would argue that the motives of charging 133 versus 131 is that 133 carries significantly higher penalties, and that they put in 133 in order to have greater leverage in plea negotiations. And I don't think, after having used that leverage for the past 2 years, that they should now that they can't prove up the 133, should be allowed to reduce it to the 131. But I cannot argue right now before you that Martinez does not support the state's position, Your Honor. And then again, I'm going to adopt whatever arguments that Mr. Shart is about to make on behalf of his client that would also apply to Mr. Kendrick.
Okay. So, Mr. Shart, I mean, I guess there's overlap on counts 1 and 2 for these two defendants, but those are the only counts that overlap, right? Yes.
Yeah, I believe that's right.
All right.
Do you have any further questions for me, Your Honor?
No, not right now. Thank you, Mr.
All right. Thank you, Your Honor. I'd be happy to answer any other questions you have.
Appreciate it.
Good morning, Your Honor.
Morning.
Okay.
Where's everybody getting these wine cranberry colored suits from?
I have arguments regarding
Thought we'd left that in
several
the 70s.
different counts in this indictment, as well as some of the overt acts, which I believe also need to be addressed, the alleged overt acts. And there's different arguments for different counts and alleged overt acts. I'm going to start with dealing with the this argument applies to the RICO count.
Can I ask you something before you get started that might assist me? I think Mr. Weinstein said you might have a chart. Do you have something that's shareable with the court, or
I don't. I don't. A chart is overstating what it is.
Okay.
We were trying to determine what specific counts, what evidence has been provided to the jurors so far in this trial.
Okay.
Let me just give a little background. I'm going to ask the court to consider Ruan v. United States, RUAN v. United States, 142 Supreme Court 2370 to 2022 case. That case explained that the commonly understood rule that as a general matter, our criminal law seeks to punish vicious will. Consequently, when courts interpret criminal statutes, courts start with the long-standing presumption traceable to common law that the legislature intended to require the criminally accused possess a culpable mind state. Applying the presumption of scienter, courts have been legally mandated to graft the material elements of mens rea into criminal statutes that are silent on the required mind state. Okay, and to bring it to this
James said it's
situation, the RICO statute is silent as to mens rea for the accused, as is, well, and not so much mens rea. Well, it is mens rea, but there's also an aspect of this that will apply to the gang statute as well. In United States v. Resendez-Ponce, 549 U.S. 102, it's a 2007 case, the United States Supreme Court wrote that the elementary legal principle is that every count of an indictment must set forth all material elements of the crime charged in order to be valid. In Division 2B of Elonis, E-L-O-N-I-S v. United States, 575 U.S. 723, it's a 2015 case, our highest court again taught that the fact that if a statute does not specify any required mental state, it does not mean that none exists. The Elonis court explained that courts have repeatedly held that the mere omission from a criminal statute of any mental or criminal intent should not be read as to dispense with this essential element. The rule of construction reflects the basic foundational principle that wrongdoing must be conscious to be criminal. In other words, just because there's no mens rea listed in the criminal statute does not make it a strict liability crime. Okay, going to the indictment in this case. Count 1, RICO. Mr. Stillwell and Mr. Kendrick, to be guilty of count 1, the jury under the law would have to find that Mr. Kendrick and or Mr. Stillwell joined the conspiracy knowingly and willingly. The state, I'm going to ask Your Honor to consider the Cotman case, C-O-T-M-A-N v. State, 342 Georgia Appeals 569. It was a conspiracy to commit RICO case. That indictment alleged knowingly and willingly. My understanding, I have not seen the indictment, but I've been told the Trump indictment also includes knowingly and willingly. In this case, the state has not alleged, and the grand jury did not return a indictment, a true bill, alleging knowingly and willingly. The indictment for count 1 is missing an essential element that has been required by the case law. Although OCGA 1614.4 fails to include knowingly and willful mens rea requirement as discussed above, when the statute is silent on mens rea, courts define the proper mens rea requirement to avoid it becoming a strict liability crime. I will point the case to Wetzel, or I think it's Whitesell, v. State, 298 Georgia 20, that discusses the concept of just putting unlawful. Does unlawful, as the state did here, does that cover knowingly and willingly? Is that an effective substitute? Our position is it is not. We believe that the Whitesell case supports that. So, Your Honor, we believe that the RICO count 1 is missing an essential element that has not been required by statute, but is required by the case law.
And it's missing Young Thug, really.
That knowingly and willfully
The leader.
Requirement, that mens rea requirement is missing from the indictment. Count 1 is subject to a directed verdict, a general demurrer and directed verdict, as it applies to both Mr. Stillwell and Mr. Kendrick. Now, turning to the gang counts, and I can get you the specific counts when I have a moment to look at the indictment. But going to the gang counts, the requirement, again, the gang statute under the Georgia Code is absent as to an essential element of the crime, which is in furtherance of the gang. That statute was in constitutional jeopardy before the Rodriguez case. The Rodriguez case saved the statute by adding an essential element to the gang statute, which is not only someone associated with the gang committing one of the specified crimes under the Gang Act, and the existence of a gang of 3 or more people, but additionally, Your Honor, they added, to save the statute constitutionally, the Rodriguez court added the requirement that the alleged illegal act must be in furtherance of the gang.
And we have not seen that
in
here.
this case, for all of the Gang Act violations, all the alleged Gang Act violations, none of those alleged Gang Act violations, on on this indictment returned by the grand jury allege that the act committed was in furtherance of the gang. Now, we know that that must be proven.
Yep.
The jury charges that we're going to give the jury list in furtherance of the gang as an essential element of this crime. And it
Judge
is
Whitaker just said,
absent in
well.
all of the Gang Act violations alleged in this indictment.
Y'all heard that?
As the indictment for those counts does not allege every essential element of the crime. Those counts are subject to a general demur and a directed verdict as well. So that's one aspect of my arguments. I can move on to my other arguments, or I can put a pin in it.
Just a second.
Right, and so what we have ultimately is that
And Mr.
there
Abate
is
just
no
gave me,
evidence, none.
Just help me out, and I appreciate that, Mr. Abate. I'm referring to count 57 for Mr.
50,
Kendrick, and
51,
50 and 51.
57.
Yeah.
Thank you. Okay, go ahead.
So
I believe it.
moving
Yeah.
on
He took care of Judge Whitaker for sure.
to the overacts, and I adopt Mr. Weinstein's arguments regarding count 2 as well. Moving on to the alleged overacts.
Can you actually, I mean, you can adopt those, but do you have anything to add with regard to count 2? Because Mr. Weinstein was basically talking about, the evidence or lack of evidence as to his client specifically.
Speak up, Judge Whitaker. We can't hear
The
you.
only evidence against Mr. Stillwell, there's no cell phone evidence. There's nothing of that nature. There's no identifications from the scene. The only evidence are social media posts and the testimony of, well, not the testimony, the out-of-court statements by two individuals, one being Quindarius Zachary, who completely disowned what he said, and back in the interviews when he was under the pressure of incarceration, under the pressure of prosecution, and we pointed out, hopefully effectively, that Mr. Zachary's story about this confession changed in material ways from when he told the story in 2015 to when he told the story in 2017. When this confession allegedly occurred changed, what was said allegedly changed, the circumstances changed, and then Mr. Copeland, I mean, you were here for that. He made out-of-court statements under the pressure of incarceration. He's openly admitted he would have said anything to get out of jail, to avoid prosecution, to avoid Rice Street, and his statements were not even that he witnessed anything, but he was told something by someone else who did not testify. So that is as far as I can tell, the entire university evidence against Mr. Stillwell, and our argument is that it doesn't clear that hurdle of surviving directed verdict.
All right.
So moving on to the alleged overacts, and I'll point out in this indictment, it lists
Not guilty of murder for
this
sure.
is a conspiracy
Rico,
to commit.
kind of iffy.
So they don't need to prove the predicate acts. They don't, those two related events within 4 years apart, they don't need to prove that, because all they need to prove is a conspiracy and one overact. So
Well, a conspiracy to commit to interrelated racketeering acts in furtherance of the enterprise.
Yes. Okay. That is fair, but they don't have to prove that the
That they
acts
occurred.
actually occurred.
Agreed.
So on page 14 of their indictment, it starts part 3, acts in furtherance of a conspiracy. It says, in furtherance of the conspiracy and to effect its objectives and purposes, the defendants committed and caused to be committed, among others, the following overt acts, certain of which constitute acts of racketeering activity. So this part 3, this isn't about, they identify some things as overt acts. They identify everything as an overt act, but they also identify certain things as falling as a predicate under 1614.3 for racketeering activity.
Mm-hmm.
The nature of this allegation is it's a conspiracy. So they don't have to prove that these predicates occurred. So essentially, my reading and my argument is that part 3 is essentially a list of overt acts. That's what it is.
Yeah.
And we are all of the same opinion. We're giving the jurors a jury instruction. It's clear, it's in the statute that the statute of limitations for the overt acts is 5 years before the date of indictment. And that's going to be, my understanding, that's going to be charged to the jury. So I, as a general principle, I do not understand if they only need one overt act, okay, and that overt act has to be within 5 years of the date of indictment. All of these other alleged overt acts that can't count, can't be used, and are completely not needed. I could see a situation, for instance, if they needed to show 2 overt acts, and one had to be within 5 years of the indictment, but one didn't, okay? It was just the last one needed to be within 5 years, but they needed to show 2. I could see the need for all of these other allegations, but that's not the case. They need to prove 1, according to their arguments, and it has to be within 5 years of the indictment. So everything that predates that cutoff date, which I think would be May 10th of 2017, it can't be used to convict.
It's not sufficient.
Well, but it doesn't add anything either because you only need 1.
Well, they also have to prove a conspiracy and an enterprise, and so.
They do have to prove a conspiracy and enterprise, and I'm not arguing that
It's true.
they can't argue about these things in closing. I'm not, I never argued that they couldn't get into these things.
Shout out to Dr. EJ.
But they shouldn't be alleged in the indictment going back to the jury because we're telling the jury, we're sending the jury a completely mixed message. We're saying you can't find an overt act that
We're not saying that. We're not saying you can't find an overt act before the 5 years. What I will be saying is it is necessary if you want to convict,
right?
that you find, if you believe there is evidence sufficient to convict, part of that evidence has to be an overt act within 5 years.
But by definition, no, I'm not, believe me, I'm going to fight tooth and nail about any duty to convict language, and I don't think there is any. But in layman's terms, if they find an overt act within 5 years, that is legally sufficient
Correct.
to authorize a conviction, which would make all of these other.
I hear what both of y'all are saying on that, and I just don't think I'm convinced that it should not even be presented to the jury because it's not sufficient in and of itself. But go ahead.
And I got to take a second to shout out Dr. EJ. Oh my gosh. I'm sorry, y'all, to interrupt. This man just dropped 50 memberships. Gotta show him some love. I got him up there in the banner. Big shout out to Dr. EJ. Since day one, he came to this channel. It's been showing major love. I wish I could tell the story about how Dr. EJ found the channel, but y'all will probably never know that one. Either way, Dr. EJ, thank you for the love and support, and thank you for all the good work that you do out here. I appreciate you, and I know there are a couple people in the chat that do as well. Let's keep it moving. And if you got a membership from Dr. EJ, make sure you say thank you.
Okay, and
I mean,
that's amazing. Thank you, Dr. EJ.
Exactly directed verdict issue anyway.
no, but I believe it is. I would say at this point, it is mere
Surplusage.
Yeah, mere surplusage, I would say, and that it's going to confuse the jury to have this list of alleged overt acts where legally none of these prior to May 10, 2017 can be used to authorize a conviction on the overt acts, for the overt act element of the RICO conspiracy. So, and then additionally, Your Honor, in all candor, you know, we stayed after court. We went through all the charged offenses in the indictment, all of the alleged overt acts in the indictment, and we did our best. We didn't have the evidence in front of us. We did our best over the night, you know, over the evening and this morning to go through those, and we either said we're not challenging it, we recall that there was evidence that would survive a directed verdict, we were unsure, or we're pretty certain there was no evidence of this.
Okay.
And so, but, you know, it's a long list. And probably I would suggest to Your Honor, for that part of this argument, it kind of be more of a back and forth as opposed to me just listing off a bunch of numbers. I can.
Well, I've got to know what you're alleging.
Okay.
Come on, Max. Bring it home.
Are you talking about, like, help me out, which overt acts you think there is no evidence presented for?
Yes.
Okay.
As well as predicate acts.
What's that?
As well as predicate acts.
Yeah, but they're,
You have the list?
Have y'all talked to the state about this at all yet?
we haven't had an opportunity.
Does the state acknowledge that there are maybe at least some overt acts that no evidence was presented on?
Yes, Your Honor, and
Okay.
we don't intend to have that go back to the jury, and so we can discuss with the.
Interesting.
All
defense
right,
counsel
I can
those acts.
certainly let y'all do that, and if there's some that, I mean, I know there were at least a few that no evidence got presented on. So to the extent y'all can reach agreement, that would be fine, and then if we want to take it up later in the afternoon after y'all have gotten a chance to get together on it, that'll work.
Okay, thank you.
And there may be some y'all want to argue about, so we can do that later. So that's fine.
Okay.
Okay, and then do you want to argue specifically as to the other counts against Mr. Stillwell?
Well-
We've done kind of 1 and 2 at this point.
Right. I've argued the gang counts.
Oh, right, and yeah.
And I've argued the RICO. The Shamal Drinks alleged murder, I think the video speaks for itself. I don't believe that there's sufficient evidence that would authorize a rational juror to come back with a guilty verdict.
I think we all agree on
We
that.
heard from Dr. Stanley, the ME. She was clear. Mr. Abate asked if someone's foot could stay on the brake and she acknowledged that a foot could come on the brake and stay on the brake after being shot in the neck. And I asked, what about lifting the foot off the brake and putting it back down? And she said that would be an impossibility. We see clear from the video
We pointed this out.
Mr. Stillwell was, I think, gone. I'd have to review my notes, but I'm going to say it was about 26 seconds, I believe, between when his car left and when that brake light on Mr. Drinks' car was going on and off. Additionally, we have the U-turn. Additionally, we have the negative gunshot residue test.
The muzzle flash.
We have no muzzle flash. It seems to me that we would have a muzzle flash. If we don't have a muzzle flash, the logical conclusion would be the shot was fired from inside the car. We have a negative gunshot residue.
And he moved.
And we heard from Mr. Coven from GBI. He followed all the procedures. Although there's been speculation and, of course, the grave suspicion, jury instruction that we all go by, we're not supposed to speculate. We're not supposed to use conjecture, I think is the word that they use. And there's just a lot of speculation. Well, what if this happened? What if he cleaned the car? And there's no evidence that supports any of those theories. So the Drinks murder, as well as the associated charges with the Drinks murder, which would include a gun charge and also a gang charge, I believe, would also be subject to a directed verdict. As it applies to the final gun charge of Mr. Stillwell's on the 17th, I'm not going to argue that there's not evidence that could survive a directed verdict. You know, we've heard it was the gun that was found on Meadowlark was registered to Taisha Alexander. We've heard Taisha Alexander is Mr. Stillwell's girlfriend at the time. But I will adopt Mr. Weinstein's arguments. This was indicted as 16-11-133. We were put on notice for 133. It's missing an essential element. And we're going to argue that the state should not be able to alter, on the eve of closing arguments, alter the charges. And also, I'm not even sure about the mechanics of how that would happen at this point. It's charged under a certain statute in the indictment. I guess
Well,
if
I
it were
think it would be just like we always do any kind of lesser included offense. I mean, that's their argument is, yeah, we may not have the elements, and they certainly don't have the elements for 133, but we have the elements for 131, and that's what should get charged instead.
Okay, well, Your Honor, every time that I've dealt with lesser included, it's because there's some sort of, maybe not surprise, but there's the evidence didn't come across quite as we were expecting or the state was hoping, or the defense requests a lesser included. We're not requesting a lesser included, first of all, but they put us on notice to defend against 133, and they left out an essential element, and now we're changing the charges on the eve of closing arguments. So that's my argument regarding that.
And I'll look this up in simple terms. Hold on. I mean, lesser included is pretty self-explanatory, but lesser included offense is a crime that is made up of some, but not all, the elements of a more serious offense. In legal terms, a lesser included offense is a charge where proving the greater offense inherently proves the lesser offense. I'll give y'all a better description of that in a second. Uh-oh, Mr. Atkins about to come up here waving his arms, karate chopping stuff. Here we go.
Your Honor.
So, for example, A bigger crime would be robbery, stealing something using force or threats. The smaller crime would be just theft or stealing something but without force or threats. Makes sense.
To aid in argument for the court, I'm going to be addressing the demur regarding count 1 RICO. And if the court has further questions on the lesser included of the 131, Mr. Abadi's going to address that. Mr. Floyd, if the court regarding the Rodriguez case, which was a case he handled on the demur on the street gang, if the court has more questions on that. And then Ms. Hilton would handle the remaining counts other than count 1. I just wanted to give the court that overview.
Thank you.
As the court's aware, Your Honor, the charge as alleged, the conspiracy, the state believes that there has been ample evidence that a rational juror could find that they conspired to commit at least a pattern of racketeering activity. And obviously, defense counsel has focused on the money or proceeds. The state believes that for purposes of directed verdict, the easier one to start with is, which is count 12 of the indictment, and the 3 criminal objectives as the court outlined in our proposed page 12 of the indictment, Your Honor.
All right.
That focus on murder, aggravated assault, acts of violence, as well as intimidation of law enforcement and witnesses, which is, I give them numbers in terms of the order of the bullet points. I believe that that's the easier argument or more efficient because there's...
Right. I mean, if the state has alleged 2 different ways of the defendants having violated RICO through a RICO conspiracy, and y'all only have to prove 1. You don't have to prove both.
Correct,
So
Your Honor.
you're saying there's at least evidence as to the overall purposes, Part B of RICO.
Correct, Your Honor. And a couple things is in terms of that objective of racketeering activity, specifically the murder and the aggravated assaults. You have from the defendant's own words their and tattoos their allegiance to YSL. I don't want to cite a litany of cases, but there's a number of factors that courts use to establish an enterprise. For example, United States v. Harris 695 F 3rd 1125 1136 is a 10th Circuit 2012 case, is display of colors. Jewelry, clothing, all of those are just 3 to start. You also have tattoos, which are permanent. And so Mr. Kendricks has slat on his left forearm and a large snake that was introduced, I believe yesterday or day before, on his stomach that goes up to his neck. You have defendant Stillwell. That's a dope tattoo, by the way. Multiple admitted exhibits in post that reference slime or reference his, for example, exhibit 430 VV is defendant Kendrick overt act 133 with a red bandana and a YSL pendant. State's exhibit 511 VV as admitted is overt act 138 is defendant Kendrick with a hat with a rat crossed out on it. State's exhibit 38 November is overt act 134 where you have Kendrick pointing at the cameraman, 2 individuals with Make America slime again. And I could go on, but the point being you have both 2015 exhibits where Detective Gaither and Detective Dennis, you had Twitters of Mr. Sledge, you had Twitters of Mr. Zachary, Twitters of defendant Stillwell, where multiple, and I'll give a few examples that actively and openly possess my slimes, YSL, this is my brew. And that allegiance coupled with the evidence at trial of the murder of Donovan Thomas to begin with, which is captures overt acts 16 through 20, which the evidence of that murder from the interview statement of Kenneth Copeland on June 10th, 2015, and Quindarius Zachary on August 15th, 2015. Quindarius Zachary's interview, which was played for the jury and is in evidence, states that defendant Kendrick and Stillwell confessed to him that very night. And defendant Williams Kondo, who rented the Hertz rental vehicle that the Infinity rep, Mr. Thomas Burnett, stated from watching the surveillance video, which I believe is 296 Yankee, that Detective Teague with APD introduced, that was an Infiniti Q50. All of those things combined, that statement of Copeland and Zachary for the why it is a criminal enterprise murder. There's no personal disagreement between Mr. Thomas, Mr. Kendrick, Mr. Stillwell. It is that rivalry of a criminal street gang that weaves through this case. And so in terms of commonalities, it is similar offenses, whether it's victims, the method and mode of operating. In this case specifically, you have a number of incidents that involve multiple YSL self-identified or APD gang detective identified members committing acts of violence together. In Donovan Thomas, you have 4. In Shamel Drinks, you have 4, at least
allegedly.
Defendant Stillwell, Mr. Garlington in the white Audi, Defendant Nichols and Miles Farley in the white Ford Fusion. On the April 28th, 2015, which was Demekion Garlington getting jumped at Club Crucial, there's a 911 call around 2 o'clock a.m. Fast forward, you have 2 shootings at 1903 Drew Drive and 1428 Adele. You had testimony from Ms. Bell, whose home was shot, crime scene technicians and responding officers. And you had in the interview and testimony of Zachary and Sledge, that act in concert, which was only 3 months after the murder of Donovan Thomas, shooting at, intending to strike rival opposition members, the ABG, Inglewood family, YFN,
allegedly,
that group. So from January 10th, 2015 to March 14th, 2022 of the murder of Shamel Drinks, the targeted acts of violence in concert by YSL members is towards the same opposition group. And that's significant for multiple reasons, because as the court knows in RICO, evidence can have multiple relevant purposes to both prove the criminal enterprise and also prove the pattern of racketeering. And I think what is important in this case is, although the state did not allege subsection alpha or bravo of the RICO statute, actual commission of racketeering activity gives clarity that this conspiracy was not some fanciful idea. It was actually alive and well. The best evidence of a conspiracy in a group is a decade's worth of similar victims, methods of operating, and public and active allegiance to this YSL enterprise afterwards that this case and the evidence through testimony and exhibits has established. So the courts, or the state, as a number of other factors, and I will not rattle off all of these cases that are other factors the court looks to an enterprise, gang and hand signs. There's been evidence admitted in testimony from APD gang detectives of the quintessential YSL hand sign, the wiping of the nose, greeting phrases the court has heard and seen in text messages and wiretaps, slat and slime.
Why don't you move on beyond
Yes.
enterprise to some of the other necessary elements?
Yes, Your Honor. So does the court have a specific necessary element that the court would like to hear?
Well, what were you going to talk about next?
And I was going to type this out, but Shane Shepard said, can someone bring me up to speed about what's going on in this moment? Please. Stepped away for a call, and now I'm super confused. They're arguing for or against a directed verdict, where if granted, that would mean Judge Whitaker would essentially be saying the state didn't do their job to prove that the indictments, or that the defendants were guilty of the indictments, and that there's enough evidence to show that, and then it would be over. And Sean P just wrote that. A directed verdict is a ruling by a judge that instructs the jury to return a specific verdict. A judge may issue a directed verdict when they determine that no reasonable jury could reach a different one, I think is what he meant to say. Our conclusion. There you go.
Fair enough, Your Honor. So to give structure, moving on from the enterprise, when in terms of agreement or the defendants agreeing to be a part of this, the state's argument, and again, the evidence can have multiple relevant purposes, the tattoos and the public, both association with YSL members and active promotion through either of that criminal street gang through their own words or social media of showing allegiance to that, posting with YSL pennants, using the common gang identifiers and hand signs and with other YSL members throughout from 2015 to as recently as 2022 shows, and the commission of the racketeering activity shows that they were a part of it. As in, you do not need, of course, a written contract. You do not need, of course, some videotaped round table of discussion. Their actions speak louder than words. And so if you need to, there's ample evidence a rational juror could find that because of the commission of murder, aggravated assault,
allegedly,
continued association, that they have actively agreed to be a part of this enterprise through their very own.
Nah. And shout out to Joshua Van Lawn, the Honorable Attorney Joshua Van Lawn, who is a former prosecutor, by the way, says a directed verdict is incredibly hard to get. When the judge rules on a directed verdict motion, they have to look at the evidence in the light of the most favorable to the prosecutor, which we know Judge Whitaker does not like making difficult decisions. I think the hardest ones she's had to make so far are going to be twofold: Young Thug's plea and then Monk Tunk's violated probation. So who knows? But I don't see it happening. So it makes it incredibly difficult to get a directed verdict, because if one witness says one thing and another witness says another, the judge has to accept the one in the prosecution's favor. Oh my gosh. What? So they will not be getting a directed verdict. I don't think so either, Joshua Van Lawn.
Actions. You also have,
I agree, 1000%.
October 1st, 2015, where Martinez Arnold gets jumped at Magic City by Kelvin Watts, Shell Kel, who of course has been talked about this week in relation to March of 2022, which shows a commonality. And then he calls Mr. Kendrick, who rides with him, where they get stopped with the multiple firearms in the Trestle Tree area, which there's been testimony from Detective Griffin, who was the lead detective on the Tierra Jones homicide. There's been detectives from multiple APD gang detectives about where Summerhill or ABG in that area is where their territory, so to speak. So that action, the January 10th, 2015 murder of Donovan Thomas, however many months later you get to October 1st alone, shows a commitment and an agreement by your very actions, willing to either assist or actively participate in racketeering activity. Furthermore, Your Honor, of course, I think the easiest of this, one overt act committed, and of course one committed within 5 years of the indictment. The state has, I will use because it's, I believe, one of the most readily assailant overt acts is the murder of Shamel Drinks, which the state believes through the testimony of Viverito, the social media introduced, is a rational juror of fact would find that to be street gang related, enterprise related. Again, there is no evidence of anything other than association with a rival gang that is in evidence of why Shamel Drinks would be murdered for going to pump up his car with gas. And so that act is certainly, it's only a few months before the indictment itself. That alone, the state believes there's been ample evidence that defendant Stillwell has committed that act along with other YSL members. And that alone, a rational juror could find happened and was for, going back to page 12 of the indictment, one of the overlying purposes that the state has alleged, which is important, of preserving, protecting, and enhancing the reputation, power, and territory of the enterprise through acts of racketeering activity, including murder. When
Max is over there
YSL
dying.
members were murdered on March 11th, retaliation was needed for the enterprise's reputation and to exact vengeance. And so that overt act alone satisfies. Of course, there is ample overt acts alleged of promoting either the gang itself or violence. I didn't want to run off a litany of admitted exhibits with.
Okay, how about
Yes, Your Honor.
are you going to talk about what the pattern of interrelated racketeering activity within 4 years of?
So, Your Honor, yes. I will take the testimony that has came out related to YFN Lucci or Mr. Bennett. And that is a perfect example of, you have, when Mr. Sumlin testified and the call was presented of Christian Eppinger, who was in the jail, calling him saying, I'm on PC with that boy Lucci, how much can I get for that? Then you have the text messages that were the color-coded charts that Viverito walked through with Khalif Adams, Demekion Garlington, and Jaden Myrick. Then you have the video that from the jail where Jaden Myrick, after that messages about stabbing YFN Lucci, through the testimony of Viverito of the, what they were discussing, actively tried to stab YFN Lucci. Then you have the post of defendant Kendrick predating that, but 2019, I believe, standing on top of YFN Lucci's.
All right, but I mean, a post isn't an act of racketeering. So talk about.
According to the state,
you have
it is.
multiple YSL gang members, all of which, I use that example because I believe it's so salient, of multiple actors, multiple ages, multiple years in time. It's the same individual that they're trying to exact violence on, who happens to be the same individual who was very close with Donovan Thomas from 2015. All of those, that pattern, the victim and the method of operation, using other YSL gang members,
All right, so which acts of racketeering activity are interrelated that have to do with that?
Right, and so what we have ultimately is that there is no evidence, none.
And the problem with this is, when it comes to YSL specifically, Max mentioned this, Doug Weinstein mentioned this as well. Everything is separated. They're in YSL, but they're committing crimes. They have not been able to show, or they being the state, how it's all intertwined and connected. And that's the problem that they're having here. And that's why Mr. Atkins is up there like, oh, well, because they're not connected. If they are, they haven't shown it. YSL is something totally separate. The crimes and the acts they committed are totally separate. It's pretty straightforward in my opinion, but we'll see.
Yes, Your Honor. So specifically,
the question is, can they be separate? If you're in a gang, does that automatically mean the illegal acts you're committing are for the furtherance or a conspiracy of that gang?
Sure.
And that's what they're trying. That's what the state has been trying to say, because they can't show somebody standing up and creating a post that said for YSL.
These niggas lacking.
so in terms of overt act numbers, you have Act 171 as the Eppinger and Sumlin conspiracy to commit murder, which was the jail call, which has been introduced. You have overt acts 165 through 167 is Bobby Hunt, Khalif Adams, Demekion Garlington, Scarface, and Jaden Myrick, which is all related to that February 9th, 2022 attempted murder of Mr. Rayshawn Bennett. And you also have, this is not an overt act, but is quite relevant for this purpose, States Exhibit 227 VVB2 is the text message from defendant Stillwell's phone where he says on February 9th at 7:31 p.m., which is, I believe, within 30 minutes of that stabbing, they just wet Lucci's BITCH ASS up, which again shows an us, a them, a concert, an agreement, a pattern, a method of utilizing contacts through jail, prison, or on the streets to concoct a plan and enact violence on a rival gang, specifically
People
a
do
rival
that
gang
all-
leader, who, of course, on January 22nd, 2015 and January 26th, 2015, mother's house was shot at 1007 Hill Street. You also have the overt act that is in evidence related to the post from defendant Williams of, if I didn't like what you did for your kids and your mother, I would have been killed you, which was about Mr. Rashawn Bennett, YFN Lucci. And so all of those things combined, without, you have words in the text messages through somewhat coded language. You have jail calls where Christian Eppinger does mention his name, but you have where they all know what they're talking about, what the goal is.
Us
They don't
versus
need
them is
to
everywhere. I agree.
Go into the agreement and the enterprise's objectives morph into one and the same in terms of they don't even, they all have the same common goal of enacting violence on a rival opposition. Is the conspiracy that could be a possibility when I actively join this enterprise is best proven by the attempted murder, and the pattern of racketeering proves the conspiracy was alive and well, in this case for upwards of a decade. And all of those, of course, I use because they're more recent. They're well within the 5 years. Your Honor, I also believe that in terms of an overall pattern, when you have, of the 28 defendants indicted, there's many connections in terms of Rodelius Ryan was, I believe, 15 when the murder of Jamari Holmes happened. Roughly, the murder happened early that morning around 4 o'clock. Later on that day, he posted a video of, I bet YSL makes the news. He has Instagram messages that are in where he alleges is quite actively stating FUCKYFN, ABG, right? He would have been 11 years old when Donovan Thomas was murdered. When Wooney Lee testifies about, we put that, on your gravestone, he would have been much younger. He doesn't come up his name in the murder of Donovan Thomas, but the fact that members who either have, actively promoted, tattooed, claim allegiance to this enterprise of different ages, of different times, have the same enemy, the same disagreement through racketeering activity in its truest sense of violence, is the similarity, is certainly for a rational trier of fact to find that
They haven't proven
there's
that,
a
though.
clear, common, interwoven theme, which I use the violence because, again, I believe it's the most salient of this point for purposes of directed verdict.
All right, can you speak to
They have not proven
whether
that,
it matters
in my opinion.
that the indictment itself doesn't contain the language willingly and knowingly, willfully and knowingly?
So, Your Honor, Mr. Floyd was going to address that much
it
more
is Mr.
eloquently
Floyd.
than I,
That's fine.
if that's
Yeah.
all right, but with the court.
Okay, thank you, I appreciate it.
Yes, Your Honor.
This is John Floyd, the RICO expert. So this is going to be interesting.
And you're going to do that for the RICO and the gang counts, the language?
Yes, Your Honor.
Mr. Floyd, okay.
Yeah, let me give me 1 second, y'all.
Your Honor, first, what was characterized, I think, as a General Demur argument, or an argument that included General Demur.
Right.
I listened to it and it was very familiar. It was very familiar because it was made and rejected over 2 years ago in the same case. The Ruan case, to which reference was made, is a United States Supreme Court case. It is not a RICO case. It is nothing like a RICO case. It was a case that involved the federal prosecution under the Federal Controlled Substances Act of doctors who had basically signed pill mill prescriptions, and the application of a federal regulation to that circumstance dealing with the validity of those prescriptions. So not on all fours, not on all threes, maybe not even on all twos. The important thing that matters is the statute. First of all, the text of the statute does not make reference to knowingly and willfully. And so the charge is in the language of the statute, which is sufficient. I mean, that's pretty much the end of that argument. To the extent that the argument blurred into kind of a special demurrer argument, the point is that first, every defendant is charged with conspiracy. There's no question about who's charged and who's not. It's very clear. It's charged in the language of the statute. Every defendant is alleged to have actually committed acts of racketeering activity. Those require a certain level of intent, and that is proof of the level of intent sufficient to commit a racketeering activity act of racketeering activity has been held sufficient to sustain a RICO conviction by the Georgia courts. They've said there isn't another layer above that. If you have the intent to commit the act and you commit the act, that's sufficient. Page 60, most of this is laid out on page 12, but also of the indictment, but also if you go to page 68, which is at the end of the overt acts, you'll see that we have specifically alleged they were committed in furtherance of the conspiracy, tying every act to that conspiracy, and therefore every individual who committed one of those overt acts to a conspiratorial agreement alleged above that they had the same or similar, which is the test under the statute for relationship. Similar is sufficient. Intents, results, accomplices, victims, or methods of commission, or otherwise were interrelated by distinguishing characteristics. I think Mr. Atkins has well covered that component of it, but it is also specifically alleged here.
Okay, that's page 67 of the indictment.
68.
67 of mine.
Oh, okay, sorry. You probably have you have the deluxe version. At any rate, it immediately follows the last predicate act, so that'll help us all navigate. The point though is that, and this is as true of the Gang Act as it is of this. The cases that have said knowingly and willfully, or the cases that talk about what has to be proven, are not pleading cases. They're not general demurrer cases. It's just a question of what does the state have to come forward with. Neither statute says knowingly and willfully. Rodriguez is familiar to me. I briefed Rodriguez. Mr. Carlson and I argued Rodriguez. Rodriguez was a facial constitutional challenge. It had nothing to do with the sufficiency of pleadings. And it simply interpreted the statute in light of a vagueness challenge. So not close to being on all fours with this situation. There is no Georgia case of which I am aware that says the state has to allege knowingly and willfully. It's purely a question of proof. That takes us to the directed verdict standard, which is simply could a rational juror find that these defendants acted knowingly and willfully. Most of the argument on that was simply the defense's interpretation of the meaning and weight of the evidence, which is not a permissible consideration in this analysis. The court does not resolve, cannot resolve those issues. And for a case that's directly on point on that is the Evans case, which I believe I cited to you yesterday. It's the other APS appeal along with Cotman.
He's a RICO expert.
And it lays out the standard in the specific context of a directed verdict or motion in a RICO conspiracy case. And the standard that it enunciates is exactly the same as... I
think you cited that yesterday. Can you
Okay, I'm sorry. It's Evans v. State. By recollection, it's a 2019 decision. I don't have it immediately in front of me, but there's only going to be one Evans RICO APS. There it is. It is 360 Georgia Appeals 596 at 600. The court said the relevant question is whether, after viewing the evidence in the light most favorable to the prosecution, any rational trier of fact could have found the essential elements of the crime beyond a reasonable doubt. And thank you.
We're not denying the crimes were committed. We're denying the crimes were committed in furtherance of YSL.
I guess I'd call it the more than one overt act being alleged, more than the jury seeing more than one overt act. I mean, the logic behind that is kind of topsy-turvy. if you think about it, there's nothing that requires the state to plead the barest minimum in an indictment. And in fact, generally to do so, we would draw a wave of special demurs. Even with this indictment, we drew special demurs with as much detail as it has.
At this point, they're not any longer challenging what you put in the indictment. They're saying whether it's in there or not, it shouldn't be out with the jury for their consideration.
Well, that comes down to if I understand correctly, an argument that there's not sufficient evidence for the jury to find the defendants acted knowingly and willfully, and that is clearly present.
Oh, no. I think we're interweaving different
then.
issues now. I thought you were moving on to the issue of whether overt acts that aren't within the 5 years,
And indeed, I
yes, it was definitely okay to put them in the indictment, whether they should go out with the
Yeah.
jury.
Okay. I understand.
If you weren't, then bring me back to what.
No,
we
I may
were
have
talking
I
about.
may have ground the gears a little bit on that
Okay.
one. But I think I just want to make sure you don't have any more questions about the knowingly and willfully issue. And if you don't, then I'll move on to that question.
Okay.
If I understand the logic chain from the defense, it is basically we only have to prove one overt act within 5 years of the date of the indictment. Therefore, anything else is, I think the term was used, surplusage. That doesn't fit the definition of surplusage. And then with particular emphasis, they've said if it's outside of that 5-year window and then would not be relevant to prove the timeliness of the indictment, that then particularly the jury shouldn't hear it because it's confusing, et cetera. I'm aware of no case that has accepted that argument, and it shouldn't be accepted because the allegations are relevant. They show the existence of the enterprise, right? This begins.
No, they don't.
It begins a long time ago.
They show a record
label. The
label.
state is not precluded from charging or presenting evidence that shows this enterprise has existed for a long time. At the kind of the extreme level of this, there are federal RICO indictments involving the 5 families in New York that discuss the entire history and formation of them, going back to the Castle Amorisi War of 1932, I think it is.
Well, like, how do you have an enterprise without structure, without hierarchy, without there being a money trail, money funneling in and out, back and forth, moves being made? So the enterprise is, hey, if somebody pisses me off, then we're gonna go get them. That's not it. I'm missing it. And Mr. Floyd's not making it make sense to me, but hey, I'm not Judge Whitaker, so it doesn't have to make sense.
So they would now span almost a century. That was not irrelevant because it tells you how this enterprise came to be, and it shows the early participation of certain individuals. It shows its longevity, its consistency. Under the law, enterprises don't have to be in operation 24 hours a day. They can have lulls, et cetera. But where they continue to exist, where the people who participate in them continue to acknowledge their existence, that is certainly relevant. And there's not an arbitrary cutoff where the indictment gets trimmed to match the statute of limitations. I'm just not personally aware of any case that's ever done that.
Okay.
Thank you.
May I respond briefly?
Well, we're still in the middle of the state's presentation, so yes, y'all both get, since it's your motion, a chance to reply, but not right now.
Good morning, Your Honor. I'll be addressing the directed verdicts as to counts 2 and 49 of the indictment, which are the murder counts. Count 50 51 and 57, which are the participation in criminal street gang activity counts, Mr. Floyd, whenever the court's pleasure, will address the general demur as to the participation in criminal street gang activity.
I mean, Mr. Floyd, did you have anything, I mean, I took your argument to be essentially, you know, the knowingly and willfully as it applies to RICO, and then basically apply the same argument with regard to the in furtherance of the gang, with regard to the gang counts. Did you have anything to add to that?
Not really, Your Honor. The statutes are quite similar on this point. Historically, the Gang Act is actually kind of a linear descendant of RICO, that some states didn't want to enact a full RICO. They just enacted a gang statute. We enacted both. They have slightly different elements, but on this...
It seems like a reach to me.
Okay. Thank you.
Thank you.
And then I'll be addressing count 62, possession of a machine gun. And then count 52, 64, and 63, which are the possession of firearms by a convicted felon.
That must be for Mr.
Right,
Kendrick.
52 isn't the 133, right?
No, Your Honor. 133 will be count
63 and 64.
63 and 64, Your Honor. So, Your Honor, as Mr. Floyd just enumerated, the relevant question is whether, after viewing the evidence in the light most favorable to the prosecution, any rational trier of fact could have found the essential elements of the crime beyond a reasonable doubt, and that's cited in Evans v. State, 360 Georgia Appeals 596, which is a 2021 decision. And first, we're going to start with count 2, the murder of Donovan Thomas Jr., Your Honor. The state has presented evidence that we believe will be sufficient for a rational trier of fact to review in the light most favorable to the prosecution. Your Honor, we have presented evidence of the June 10th, 2015 video recorded interview of Mr. Kenneth Copeland at the Atlanta Police Department, which is Exhibit 378, Yankee Echo.
But y'all gave him immunity, though.
In that video, Your Honor, Mr. Copeland discusses a co-conspirator statement of Demekion Garlington, in which Demekion Garlington tells him about the murder of Donovan Thomas, that who was involved, which was Mr. Stillwell, Mr. Kendrick, Mr. Justin Cobb, Mr. Demas McMullen. In that interview, Mr. Copeland speaks of his whereabouts on the day of the murder of Donovan Thomas, beginning on early in the morning hours, and when he eventually meets up with Mr. Garlington at a gas station on Cleveland Avenue. He further tells the detectives that Mr. Garlington told him that those 4 individuals, again, Mr. Stillwell, Mr. Kendrick, Mr. Cobb, and Mr. McMullen, had committed the homicide of Donovan Thomas Jr. He told them about the type of car that they were in, which was an Infiniti vehicle, the location of where Mr. Donovan Thomas was, which was the barbershop on 330 McDaniel Street. We then also introduced the August 2015 statement of Quindarius Zachary, which was State's Exhibit 531Y, which Mr. Zachary corroborated some of the same information that Kenneth Copeland provided. He also added the additional information or evidence in that interview, which was Mr. Stillwell and Mr. Kendrick at the condo of Jeffrey Williams confessed to him that they had participated in the murder of Donovan Thomas Jr. Those statements and the details of those statements are corroborated by certain other evidence that has been admitted. We have the barbershop surveillance video, which is at 292 Yankee Alpha through 292 Yankee Delta. That video surveillance showed Mr. Donovan Thomas Jr. outside the barbershop moments before a silver and color vehicle, which was identified in testimony as an Infiniti, drove down the street and shot several rounds of gunfire at and towards the direction of Mr. Donovan Thomas Jr. We also have the Texaco surveillance video, which corroborated Mr. Kenneth Copeland's statement. In his statement, Mr. Copeland tells officers
course they
that Demekion Garlington told him that they met at the Texaco gas station, that they switched cars, which he explained that Mr. Kendrick initially arrived in a Pontiac Bonneville, and that the gray Infiniti vehicle met at the Texaco gas station. That was depicted on the surveillance video. In the surveillance video, you see Mr. Kendrick walk into the gas station. You see Mr. Kendrick approach a silver Infiniti vehicle. You see both of those vehicles leave out of that gas station at the same time. Your Honor, yes, what we do not see is when the transition occurred between Mr. Kendrick getting out of the Bonneville and getting into the Infiniti, but we believe there's a reasonable inference that happened off camera outside of,
come on.
we believe behind the Texaco gas station. Mr. Copeland also discussed in that interview that the car that they used was rented by Mr. Jeffrey Williams. We were able to admit State's Exhibit 334Y, which was the rental agreement from Hertz Rental, which showed that the vehicle was rented by Mr. Williams about 2 days before the homicide of Mr. Donovan Thomas Jr.
Which is
we
not
then
illegal.
also have phone records that corroborated what Mr. Copeland said. We have the phone records that show that when Mr. Copeland woke up in the morning hours, or the afternoon hours, of January 10th, 2015, he was located. He told police he was at his girlfriend's home, which was in the village of Carver Homes. The phone records corroborated that his phone was at that location at that time. He then proceeded to tell officers that from leaving his girlfriend's house, he went to the green store. The phone records corroborated him going to the green store. The phone records then corroborated what he told police, that he then went to the McDonald's the McDonald's restaurant, and that's where he met with Demekion Garlington, and that's when Demekion Garlington explained to him everything that occurred. Mr. Copeland was also able to tell the police that Mr. Demise McMullen actually was at the McDonald's when he arrived, or when he met with Mr. Garlington. The phone records corroborate that Mr. McMullen actually made contact with Mr. Williams about 6 minutes after the murder of Donovan Thomas. Immediately following the phone call with Mr. McMullen, there is a number of different phone calls to a variety of different people, specifically an individual by the name of Kelvin Treadwell, OG Bentley. Both Mr. Copeland and Mr. Zachary, in their statements, advised that after the murder of Donovan Thomas, that the guns in the vehicle were given to Kelvin Treadwell, also known as OG Bentley. The phone records corroborate that a number of different phones, Mr. Williams' phone, Mr. McMullen's phone, all ping in the location in and around near Kelvin Treadwell's home after the murder. Their phones ping off of the tower closest to Mr. Treadwell's home. So that evidence has come in, Your Honor.
Which means nothing.
We have the autopsy photos that show that Mr. Donovan Thomas was murdered and killed with certain types of shell casings. Your Honor, we have the jail call.
Wait. Were used by certain types of shell casings that were linked to who? We know he was killed. Who were you able to link that to, Ms. Hilton?
With certain types of shell casings. Your Honor, we have the jail call of Mr. Stillwell. I do not have that exhibit number, which was entered after his preliminary hearing, Your Honor, in which at the preliminary hearing, we know from both Investigator Thorpe and Deputy District Attorney Michael Sprinkle that during the preliminary hearing itself, they didn't use any names. They used witness number 1, witness number 2. However, on the jail calls that we have both with Antonio Sledge and Mr. Stillwell, that they identified one of the witnesses being Little D. Little D was the nickname for Quindarius Zachary. And what Mr. Stillwell said during that call is they snitched on me. And I'm paraphrasing. It was never, they lied on me. It was never any other language, but we have that evidence. We have
What does
that
this have
in
to do
evidence.
with anything?
We also have in evidence, Your Honor, States Exhibit 477NN, which is the Slat Talk video in which Mr. Stillwell says the words, "I just beat a murder rap, pay my lawyer $30 for that." Also, he has in his,
He didn't.
introduced more recently another song that Mr. Stillwell has, which was called BS or Bullshit. And in that song, he says, "Beat the Hom, no evidence." We believe that that is another reference to the murder of Donovan Thomas. We also have State's Exhibit 436 VV, which is Mr. Stillwell after in 2019 posting a picture with himself in a slime sweatshirt with the peanut gravestone in Spanish, then immediately deleting that from his from that Instagram post within a few minutes after posting it, Your Honor. So we believe that there is sufficient evidence for the jury for a rational trier of fact to be able to find the essential elements of
If you
the
want to
crime
call
beyond
that evidence, fine.
Next,
Bar
Your
is just
Honor, I
really
will
low.
go to count 49, the other murder count in this indictment, Your Honor. Your Honor, the state has admitted crime scene photos of the crime scene at the time. That's going to be State's Exhibit 65, Victor through 115, Victor, specifically 79, Victor has Mr. Shamel Drinks deceased inside of the car.
We definitely know he's dead.
Yes, inside of the car. We then have, Your Honor,
Dang,
the
Judge
surveillance
Whitaker.
videos from, specifically, I'm going to focus on the BP surveillance video, which is State's Exhibit 116 VV, and the FedEx surveillance video, which is State's Exhibit 117 VV. In both those videos, Your Honor, initially, before we know who was identified, we see a white, extremely darkly tinted Audi vehicle come to the gas station. We also see a white Ford Fusion. We see individuals from those two vehicles enter into the gas station. We later learn that that is both Shannon Stillwell, Quarmavius Nichols, and Miles Farley. We have the evidence that in that same surveillance video, within 5 to 7 minutes after they are at the location,
We definitely
Mr.
know he's
Drinks
dead.
arrives at their location in his red vehicle. He is seen walking inside of the store. That surveillance video then shows that when Mr. Drinks' red vehicle leaves, very soon thereafter, both the white Audi that's tinted leaves the location, as well as the white Ford Fusion. We do have a wiretap telephone call, which is State's Exhibit 437 VV. The call, I can't recall the page number at this time, Your Honor, but the call that is at 9:59 p.m. based upon the wiretap data, which is a call that tells from Demekion Garlington telling another occupant of the white Ford Fusion to immediately get on FaceTime, Your Honor. There's evidence from even Mr. Demekion Garlington's wiretap where they talk about getting on FaceTime when they don't want
What
to
about the
discuss
third
certain
car?
things on the phone. We also heard that from expert witnesses that FaceTime is a mechanism that is used when criminal activity is going to take a foot because it cannot be tracked. At 9:59, that call takes place. We then see on the FedEx surveillance video at approximately 10:01 p.m., Mr. Drinks arrives at the lights, as well as the white Audi, as well as the white Ford Fusion. The white Audi and the Ford Fusion stay at the light for approximately 2 minutes, Your Honor, before they take off into traffic, running the red lights. Your Honor, at that time, the red vehicle never moves again. We see from the ankle monitor records, Your Honor, based on the evidence that was provided in the ankle monitor records, that within a minute, Mr. Stillwell's ankle monitor goes from 18 miles per hour to 90 miles per hour. We know from the phone records that both cars travel in the same direction towards Fulton Industrial Boulevard, where we believe they go to a music studio. We then have from Mr. Stillwell's phone a phone note in which, I'll paraphrase, he talks about dropping the ops. Very soon thereafter, and that is right after Mr. drinks is at that light. We then have, Your Honor, again, phone records that put both Mr. Stillwell, Mr. Farley, Mr. Nichols all in the same area, which is the area of the gas station in and around the same time. Your Honor, we have social media posts. Oftentimes we don't have motive, but we have social media posts in this case that were posted
Shout out to Big Burrito.
Between March 11th, 2022 and March 15th, 2022. One, we know that on March 11th, 2022, the evidence showed that 2 YSL associates were murdered on a highway, both Mr. Christian McMiller and Mr. Darius Ford. And we have in evidence State's Exhibit 452 VV, which is a post from Mr. Stillwell. And I believe this post is on March 11th or maybe March 12th that says, "Just rest, Mac, I got you." Then we also have a post, which is 458 VV, that is posted on March 11th with Mr. Stillwell posting, "I ain't gonna be the only one crying." Then on March 15th, 2022, we have Scarface, who is, we believe, in the car with Mr. Stillwell at the time that the murder takes place, posting a picture of both Mr. McMiller and Mr. Ford saying, "We got y'all boys." And that is only hours after the death and murder of Mr. Shamel Drinks. We then also introduced, Your Honor, the rental car agreement, which showed that
That's a tough piece of evidence right there.
Stillwell rented this vehicle on March 14th, 2022. And then we also have the wiretap information that shows that he went to a
Imagine posting that on social media after you shoot somebody. That's crazy.
tinted window car place and got deep tinted tints on this car on the day that this occurs, Your Honor. And then we have text messages while in January of 2022 saying that he goes op hunting. So, Your Honor, we believe that that evidence is, quote the right language, that evidence is evidence that a rational trier of fact could find the essential elements of the crime of murder beyond a reasonable doubt.
Well, not beyond a reasonable doubt.
Next, Your Honor, I will
relax
go
on that.
to count 50 and 51, which are both the participation in criminal street gang activity as to Mr. Shannon Stillwell, and then count 57 as to Mr. Diamante Kendrick. Mr. Atkins touched on this somewhat, but I'll just add some additional evidence that has been presented. We have the testimony from investigator Mark Belknap, Trontavia Stevens, Walter Murphy, Antonio Sledge. Well, sometimes it was easy to get out, sometimes it wasn't, but they all have said that YSL is a gang. We have evidence of the tattoos of Mr. Kendrick, which was 518 VV to 520 VV. Which,
before you do the
it's not illegal to be in the gang.
Can you address the 58 through 61 drugs and machine gun, and whether there's evidence of constructive possession for Mr. Kendrick?
Yes, Your Honor. So first with the possession of machine gun, which is count 62.
Yes, sorry.
One, just the proof that of the gun itself, we have the...
I know that that's established.
Okay. So as regarding Mr. Kendrick, Your Honor, there is evidence that we know from his phone that he had been at the home earlier that day. We know that based on testimony from Officer Samba, that he fled from the home.
No, he was, okay.
And apprehended, Your Honor, and we believe that that would be some evidence of consciousness of guilt, the fact that he fled before the police even, I think, hit the door of the home, that he had fled out of the home, Your Honor. We believe that inside of the home, there were a number of guns, both from the pictures, you can see that there's a number of guns outside on the kitchen table. There were some guns.
Remind me where the machine gun was found.
The machine gun is actually downstairs, we believe, in the basement of the home.
Not the basement.
By
laying on the floor?
Yes, laying on the floor underneath the couch, Your Honor. It is the state's theory, Your Honor, that when
it's the state's
SWAT team
theory,
did not make a quiet announcement to get
the state's evidence will show.
And it is the state's theory that when the announcement was made, you could tell from some of the images, we believe that there was an effort to hide some of the items that were inside of the home. This gun was kind of maybe kicked underneath the couch where you had to pull it looks like they pulled the couch back in order to observe this gun that was actually in the basement, Your Honor. To address the drugs, Your Honor, which are counts 58 through 60, which is the possession of marijuana with intent to distribute, the possession of codeine, and the possession of cocaine, Your Honor. I believe all of these items, which was Stacy Exhibit 12XX, 17XX, and 18XX, the marijuana, I believe, was out in the open. If my memory serves me correct, I need to pull up the picture again, but I believe that the marijuana was out present and open in the home, Your Honor. That specifically 18XX was not hidden. 17XX was the marijuana with guns that was found in a cabinet.
Were they in possession of it though, as Doug Weinstein said?
Inside of the kitchen of the home. And then the codeine, if you give me a moment, I just want to pull up the picture so I can make sure I know where the codeine was found inside.
They're like in a box in a closet, right?
I believe they were, but I thought there was some that was out as well. But of course, indulgence.
Oh, Uncle's back. What's he doing? Yeah, but they weren't in possession of the weed, and they couldn't even prove that Yak Gotti was in the house. Viverito tried to say he was running out of the house. Wasn't caught on body camera.
Yes, Your Honor, the codeine was found in the closet and then in the bathroom upstairs in the house. And then the cocaine was found in the pantry as well. In that same bag, there was a bag that had in the pantry that had the cocaine and the cocaine and the codeine, Your Honor.
And the marijuana was out where, in the kitchen?
So there's one in a Tupperware container that's in the on the kitchen counter, and then there's the bag of marijuana that was in that cabinet with the gun that's in the cabinet above the, I think, the refrigerator.
Was there any evidence presented that Mr. Kendrick was like staying there as a residence, or just that he was there that day?
No, Your Honor, the evidence
That's
that
what
we
I just
have is that
mentioned.
he was present that day, and we believe that he had been present maybe a few days before.
We believe, but they don't have.
Right. And so what we have ultimately is that there is no evidence, none.
But not continuously.
Not continuously, no, Your Honor.
And so can you address
Garbage.
constructive possession?
Your Honor, it's just the state's position that
So
at
no. So the
time-
answer is no. You cannot.
of Mr.
Just say no.
Kendrick being at the home, that he had knowledge of the drugs being present in the home, Your Honor. Specifically the marijuana, Your Honor, as well as the guns being in and around the home.
He's only charged with a machine gun, right?
He's charged with the machine gun, and he's charged with possession of a firearm during a commission of felony with all the other guns that were found inside of the home, Your Honor. So he's charged both.
That's the count. Which
That's-
count is that?
Yes, Your Honor.
That's count 63.
Yeah, so count 62 is the machine gun, and count 63 is possession of firearm by convicted felon for the other, in addition to the machine gun, the other guns found inside.
Where are all of those found? Remind me if you don't mind.
Yeah, they're found in different locations. So I believe the FNH57, I don't, So 13XX, Your Honor, is an FN 857, and that's found on the kitchen counter behind like a green dinosaur.
Wow.
And then there's the two firearms.
Can you show me a picture of that? Let me join Zoom.
I'm logging into the Zoom now.
Yeah, I am too.
They can't even prove that he was in the house when the guns and the drugs were there. There we go. They're loading up the pictures now.
This is, I believe, the FN H57, I think it's 57. And that's in the living room area.
All right, those are just sitting out on the counter, right?
Yes.
All right.
And then
That's in the cabinet.
That's
above, yeah.
yes, Your Honor,
So a lot of this looks like it's documenting what the guns are. I just want to see the ones that show where they were found.
so these are two more.
Those are in the cabinet.
Those are in the cabinet.
Up above, yeah.
This is the pantry, Your Honor, where this other gun was found.
That's like I think somebody referred to it as like the hidden
Yes. It's
door or something like that.
Yes, Your Honor.
And that's where the codeine's found too?
Yes, Your Honor.
And the cocaine?
Yes.
Okay.
And then this is where the machine gun is found, Your Honor.
And that's after the couch is moved or after it's,
Yes, Your Honor.
any idea do we have a picture of the couch before it was moved?
No, I don't think so, Your Honor. I think once they moved it and found it, they took a picture of it.
Okay. All right, thanks. All right, and then you were gonna circle back to,
Your Honor, I guess there's one more gun to be shown.
okay.
And there's one found in the upstairs bedroom.
Whose bedroom is that?
We believe this is,
Why do you believe that?
the room.
We believe.
We think that the ID for Jimmy Winfrey was found in this room.
For who?
Jimmy Winfrey was found
Okay.
in this room.
All right.
Go back to the gang count, Your Honor?
Yes.
Okay.
And address Mr. Kendrick's count first, which is 57.
Your Honor, it's the state's position, Your Honor, that the drugs inside of the home were all, specifically the possession, the codeine, Your Honor, as well as the marijuana with the phone counters were being prepared for distribution. If you remember, there was the large pail of codeine that was found, a number of different bottles being found, Your Honor. As you also saw, although not charged because it's not illegal, was the YSL drink juice that was inside of the home, Your Honor, which looked like that was being packaged for some type of sale or distribution of itself, Your Honor, that these particular drugs were possessed in furtherance of the criminal street gang to sell.
How can they prove that?
Your Honor, to sell both marijuana as well as to sell the codeine. We have evidence of the money counter inside of the home, Your Honor. Mr. Kendrick was at the home, was present at the home. There are a number of different guns present inside of the home, which we know guns are usually kept with drugs in the sale of drugs, Your Honor. And so based on that evidence, we believe that there's sufficient evidence to go back to the jury to show, at least for that count, participation in criminal street gang activity, given that evidence that has been admitted into evidence, Your Honor.
We didn't have any evidence as to like the weight of the cocaine or anything like that, did we?
Yes, I believe the GBI did.
Okay, maybe y'all just didn't highlight that.
Yes.
But that wasn't a.
That's not an intent
That
to
wasn't a
distribute.
distribution
No,
amount.
no,
Okay, right.
that's simple
All right.
possession. And Your Honor, specifically regarding the guns, because we also charged count 57 with the guns. The state believes that they were still in the midst of a gang war. This was only 2 months after both Mr. McMiller and Mr. Ford had been murdered. There had now been the retaliatory shooting of Mr. Shamel Drinks. We know that 2830 Waters Road had been shot at multiple times. And so we are now still in the midst of, or we believe, a gang war. And with that amount of guns and weapons inside of the home, a machine gun, Your Honor, that these were tools, whether it was to protect themselves or get ready to go and continue war, that they had this ample amount of firearms inside of the home, all in furtherance of this gang war that we believe is still going on even to this day, Your Honor.
Okay. All right, moving on to Mr. Stillwell's other counts.
Yes, I believe Mr. Stillwell's count that I have not addressed yet our participation in gang activity, which I believe
Yeah, save that one to last. Let's talk about the underlying ones first, if you don't mind.
So I believe his next count is possession of a firearm by a convicted felon and possession of a firearm during the commission of a felony, Your Honor. I believe those are the last two.
Okay, hang on then. So
and I will address the possession of a firearm during the commission of a felony, and then Mr. Abati will address the 133 possession of a firearm by a convicted felon.
give me a second. in the indictment. I'm sorry, they're kind of not all together in the indictment. I'm
No
not
problem.
sure of.
Yeah, and proof of intent to distribute is tough because if you just have over a certain intent to distribute, excuse me, if you have over a certain amount, then that's pretty open and shut. If you have over a certain amount weight wise, then it's intent to distribute, period. And if you got scales and baggies,
for count
then you're
54,
super cooked.
Your Honor, possession of a firearm during the commission of a felony. Mr. Drinks was killed with, I believe, a .40 caliber, I believe, a Glock handgun based upon the GBI testimony that came in.
The law
Your
says you
Honor,
can't
there
have
was
that many
testimony
drugs.
Yesterday,
Unfortunately,
from Investigator
or
Viverito,
fortunately,
that
depending on
in
how
a
you look at it.
video that's was created about an hour before the murder of Donovan Thomas, that there is a gun that could be consistent with a Glock 27, which is a .40 caliber handgun. That is the evidence that we have, Your Honor. We never recovered the handgun used in this case, Your Honor, but there is evidence. I believe if we look back to the Donovan Thomas murder, that after
There's still too much.
that murder, they got rid of the gun. It's the state's theory that the same thing occurred in this case, that after the murder of Mr. Drinks, that they did get rid of the Glock handgun that murdered Mr. Thomas. But we do know that he was, Mr. Drinks, but we do know he was killed. It is the state's theory that Mr. Stillwell shot and killed him, and would have shot and killed him with a .40 caliber handgun, Your Honor.
You believe that, but where's the evidence?
All right, and then the other gun one was the one that was tossed, or that.
Yes, Your Honor. Did we know from Miss
Right before they were arrested.
right before that? I'm sorry, that's count 60.
Okay, that was registered to.
Miss Taisha Alexander, Your Honor.
All right.
And I do believe for the gang, Your Honor, Mr. Adkins discussed that within the RICO when he talked about the gang. So
Thank you.
thank you, Your Honor.
All right, reply, argument.
I don't feel the need to go on and on, but Your Honor, I just wanted to clarify one thing. I felt that there was kind of a straw man where my argument was being presented about the overacts alleged, that I didn't, the state needs to give a history, and the jury needs to hear about the history of different acts. I'm not saying that those overacts aren't relevant. And obviously, we've been in here for a year. They've presented evidence of those overacts, many of them, not all of them. My assertion and my argument is merely that the state should not be allowed to create an indictment with alleged overacts that are outside the statute of limitations, and then a listing of those overacts goes back to the jury as part of the indictment. And that's all I'm arguing with that. Not that it's irrelevant, not that they can't get into it, because obviously they have.
I understood that to be your argument, and I appreciate that. Thank you.
Your Honor, the state stood up here and gave a very thorough response to our motion for a directed verdict. But they never once, and I was listening very carefully, and you specifically asked them about the constructive possession. They never once made argument regarding any intent shown by Mr. Kendrick on possession of those drugs or guns. They made some arguments perhaps about ability, although even that I think was somewhat strained, where you have firearms that are in cabinets and closets and wherever, and he's just a guest in the home. The issue of intent is one, again, that you're going to instruct the jury on in the jury instructions. You also have a mere presence that you're going to instruct the jury on. So Mr. Kendrick, while he may have been present in the home, there hasn't been any evidence regarding intent, Your Honor.
None.
Right, and so what we have
why don't
ultimately
we
is
take,
that there is no evidence, none.
I don't know if lunch is here yet, but why don't we take a break for a little while? Y'all can see if you can get together and come to whatever agreement you're going to come to on overt acts that there hasn't been evidence presented on. And I want to read the motion that got filed and look at some of the case law and maybe review some of the evidence. And then, presuming I don't grant the motion on every count, which I think maybe there's been some acknowledgement that at least a tiny bit of one count might be able to go forward. We need to finish the charge conference. You were going to say something, Mr. Sharp?
I was just going to let Your Honor know that.
Told you.
Calling it a chart is really giving it way too much credit. But I did email that to Ms. Persfield and the state, and I will update it after I confer with the state and figure out.
I didn't mean to oversell what we had put together last night.
It's fine.
One other thing, as far as the charge conference goes, I did submit one additional proposed jury instruction to Ms. Percival.
I'll be interested to hear your argument on that.
Thank you.
And the state's response.
Yes, Your Honor, and on that note, we have discussed the charges for the overt acts that the jury would not otherwise be instructed on, like armed robbery. I just want to let the court and defense know that the state has and is about to submit to the court and parties the underlying crimes of the overt acts that are crimes and not otherwise alleged.
All right, thank you.
And Your Honor, when it's appropriate, it can be later, but could the lawyers from each side approach about a scheduling matter?
Y'all can do that now.
All right, so let's be real. Judge Whitaker just told them she's not granting a directed verdict, and we kind of knew this. No surprise there. And thank you to the Honorable Attorney Joshua Van Lawn for explaining to us why that would most likely be the case. It's just something that's really difficult to do. So let me get these super chats in here. And then I still want to go back and review this coverage from yesterday, because I think it was a little bit more interesting than Judge Whitaker holding us up, already knowing that she's not going to grant a directed verdict. Nobody's surprised. Shout out to my guy, Henry Resilient, gifted a membership. If you got that membership from Henry, say thank you. We've also got Hallie P in here. What does she say? With the 5-bomb. I think if Paige feels obligated to let the jury do something so they didn't waste 10 to 12 months of her time, the trial is a waster of time. I agree. Yep. And she's going to let the jury handle it, which is what we saw from the beginning. The moment she stepped in the court, I had a feeling that's the way things were going to go. The 2-bomb from Jane Q Public says, I believe I could fly. I believe I could touch the sky. Shout out to you. That hard body hope. Lord have mercy. Hey, yo. I should have read that before I read it out loud. Throw the whole trial away. I think most, if not everyone who's in here, will agree with you. But let me see. What did y'all say in this poll that I put in the chat? I asked you, will there be a directed verdict today from Judge Whitaker? And it looks like. Interesting. 50% of you said yes. 49% of you said no. So it's almost split. Yeah. I didn't vote, but if I voted, I would have voted no. Judge Whitaker, she wants us to go through the whole process, and she's proven that and shown that time and time and time again. Let's get back into this messiness from yesterday, and then I'll get y'all up out of here while we take this break, which actually, let me double check and see. Knowing Judge Whitaker, they're probably not going to come back until after lunch. We'll see.
The witness back in and the jury back in.
Yeah. Judge Whitaker already said, well, it seems like there's going to be a little piece of evidence to move forward, which I somewhat agree with her. Sounded like Judge Whitaker cracked open another soda. Let's get Big Burrito back in here and the jury.
And I'll give y'all my ruling on the motion for directed verdicts, motions for directed verdict, and we can do whatever else needs to be done with regard to the charge conference. However,
what's she saying? They're going to go to lunch? Hold on.
I guess on the overt,
I knew she was going to get out of
do
here.
y'all mind doing the overt act thing and then get
What is she saying? She's basically saying, I'm willing to take an extra lunch. Hold on.
On the motion for directed verdicts, motions for directed verdict, and we can do whatever else needs to be done with regard to the charge conference. However, I guess on the overt, do y'all mind doing the overt act thing and then getting that to me and then going to lunch so that I can be have that with me? Okay.
She's going to lunch. All right. Thanks for nothing, Whitaker. Here we go.
Go ahead, Ms. Holmes. Thank you, Your Honor. I'm going to publish now 397 VVF.
She's looking like a vampire. Y'all better leave her alone.
And looking at 397 VVF, do you see that same PJV2 plus VR location that you saw on the spreadsheet?
I do.
Okay. And are you able to tell where that intersection is?
I am.
Where is that?
At Windsor, it looks like just north of Rawson or at Rawson.
Now, on cross, do you recall when Mr. Shard asked you about the handgun that was on the table at 2830 Waters Road?
I do.
And he asked you about three types of guns: Springfield, Sig Sauer, and Smith & Wessons.
Yes.
Right. First, let me ask you, do you know if a Springfield makes a .40 caliber weapon?
They do.
Do you know if a Sig Sauer makes a .40 caliber weapon?
They do.
And do you know if a Smith & Wesson makes a .40 caliber weapon?
They do.
Permission to approach, Your Honor?
You may.
I'm going to show you what's been marked as State Exhibit 531 VV, 532 VV, and 533 VV for demonstrative purposes only. Tell me if you recognize those types of weapons in 531, 532, and 533 VV.
One is a Springfield XD firearm, one's a Sig Sauer P229, and one's a Smith & Wesson.
And looking at those three weapons, are they able to illustrate what you were talking about, the distinction between the Glock 27 as well as these other types of weapons?
Yes.
Okay. Your Honor, this time the state would like to admit 531 VV, 532 VV, and 533 VV for demonstrative purposes.
Admitted.
So let's get it over with, Judge
Permission to
Whitaker.
publish?
You may.
Looking at 531 BV, are you able to tell the jury about the distinction you were making between the grip of, say, a Springfield versus the Glock that you were talking about on the table at 2830 Waters Road?
Yes, it would be along the bottom part of the grip.
Say it one more time.
Along the bottom part of the grip. Should be right. You might have to scroll it up for the jury.
Or can you use the one at the...
Or, I'm sorry, right here. This is straight across.
It's a nice
With a
gun.
little bit of a piece that comes down towards the
favorites.
back.
And is that distinguishable from what you were describing with the Glock?
Yes.
All right. Now looking at 532 BV.
She's not a gun expert.
Again,
why
the
they're
same
asking
thing. You'll
about
see
this.
there's something that comes down in the back, but otherwise it's higher up towards the front.
And you have to speak into the mic for me because I can't hear you.
Sorry, it's lower towards the back, higher up towards the front. So it kind of a part that dips down in the back and then comes up.
And for 533, I'm sorry, what kind of gun is this 532 BV?
I believe that's the Springfield XD.
Or 532?
I'm sorry, which one? 532?
There's an
It's a
echo?
6-hour
Should be.
PC29.
Okay. And then 533 BV.
You'll see again here, there's a piece in the back, but then once you get to the front, it's just straight across.
And then what type of weapon is 533 BV?
That would be the Smith & Wesson. I'm sorry, the 530. Yeah, the Smith & Wesson.
Now I want to go
I know the world's in my bag.
to, and Mr. Kokomo, if you can help me out, please.
I gotta put some respect on super mega expert
DS57A,
detective
DS57C,
officer
and
hybrid.
DS58A.
Dorito. They retired Miss Love. Ms. Love. As our guy Tunk used to say. Ms. Love did him dirty.
And while that's being pulled up, Mr. Shard, they asked you whether or not there were people, I guess, not to say looking for Mr. Stillwell, but that there'd be some concerns for his safety because of the Tierra Jones killing. Do you remember a line of questioning regarding Tierra Jones?
Yes, several years ago, that was an incident.
When was the Tierra Jones killing?
It was several years ago. I can't remember the exact date.
Do you remember the year?
Not offhand.
All right. Now looking at, I believe this is DS57A. Is this the communication between Mr. Stillwell and Miss Alexander regarding the shooting at McDaniel? Excuse me,
It is.
at I-20 and McDaniel.
It is.
Do you see any response from Mr. Stillwell in the text message that's, dang, babe, I was just at that intersection. Or, man, glad it wasn't me. I just missed being at that location.
I do not.
Do you see any
Lauren, you
text
say you can't
messages to Miss Alexander that says, man, I was just at that BP gas station a little while ago. That's up the street from there.
I don't.
Let me try this. Hold on, let me rewind it for y'all.
Mr. Stillwell in the text message.
that better?
that's, dang, babe, I was just at that intersection. Or, man, glad it wasn't me. I just missed being at that location.
I do not.
Oh, your earbuds died.
Do you
Oh my
see
God.
any text messages to Miss Alexander that says, man, I was just at that BP gas station a little while ago. That's up the street from there.
I don't.
I want to go to DS58.
Okay.
And is that the communication between Mr. Stillwell and his grandma?
It is.
All right. Do you see where she says, "Hope you are not near Windsor Street shooting on the news," and says, "Answer me, please"?
Yes.
Does he say anything to his grandma? I'm like, "No, what, grandma? I was over there earlier, but it's not me."
He does not.
Now, we talked about searching for on Fox 5. Do you remember talking about the searches on Fox 5?
Yes.
Okay. Did you see any searches on March 14th when both his grandmother and Taisha were asking him about whether or not he was around that location or if he heard about it? Did you see any searches for the shooting on that day, on March 14th or in the early morning hours of March 15th?
No.
Are all of the searches on March 17th?
They are.
And is that the day he was ultimately arrested for these charges?
Yes.
Yeah, they weren't feeling Miss V.
Now I want to go to Stacey Exhibit 437 VV.
VV?
Page 2145. April 1st, 2022 from 11 minutes to 11:20 seconds into that call.
What time's again, I'm sorry?
11 to 11:20. And you can pause the call.
Yeah.
Yeah, that's all it is. Just assume. Hey.
Yeah, I already know. Like when they got down, go to wiping down, doing them got down, them. You know how they gunpowder, forensics, all this shit there.
Yeah.
You gonna come back clean. You see what I'm saying? So I ain't tripping on that.
Uh-huh.
Yeah.
During that call, he says when they talk about that GSR stuff, it's going when they wipe it down, it's gonna come back clean.
Correct.
Ooh, they cleaned the car. There's no evidence to that though.
At any point, he's saying, I don't know I don't even know what any of this is about.
No.
Does he say to his best friend, I don't even know why they took this?
Your Honor. Proper commentary also affects on that.
Sustained.
Does he say to Demekion Garnett on this call, I don't even know why they took that car?
No.
My gosh.
Does he say to Demekion earlier in the call, that Miles and Quay, they don't need to worry?
Yes.
Miles and Quay, were they both in a Ford Fusion?
Yes.
Okay. Were they in the car that was furthest from Mr. Drinks?
Yes.
Did you hear when Mr. Stillwell told Mr. Garlington, I told them not to talk to the police, don't say nothing? Did you hear what he told Mr. Garlington that?
Yes.
And this entire call is on the contraband phone?
Correct.
That can't be monitored?
Correct.
Or outside of it being a wiretap, cannot be monitored?
Correct.
LPR readers, what information do you need about a car in order to look for a car on an LPR reader?
A license plate, a tag number.
Do you even know the make and model of a car?
It's not illegal.
Overruled.
You can try by make and model, but it's not very accurate sometimes, especially at night.
With the two cars that we saw in the FedEx surveillance video, were you able to see any license plate information on either of those two cars in the FedEx video?
I was not.
And at that FedEx video, is that where we see the Audi and the Ford Fusion run the red light?
Yes.
TV?
Course
Damn,
no.
sure.
No further questions.
All right, Recross.
All right, here we go. Recross.
Thank you, Your Honor. May it please the
What
court.
we're all waiting
Investigator
for.
Viverito, good afternoon.
Afternoon.
So, you were just asked about LPR readers, and I think the context is figuring out the car that did the U-turn and the car that sped up behind Mr. Stillwell.
Okay.
And you said you need a license plate, and that you can't see the license plate from that video.
Or if you have it, sometimes a make and model search might work, but at night, in my experience, it's not very accurate.
Well, are you aware that it was in fact a make and model search that night that revealed the license plate of the white Audi and the white Ford Fusion?
No.
Okay.
Of course not.
That Detective Ender, I believe her name is, did? Okay. So, the bottom line is, LPR search by make and model, it's never going to work if you don't try, is it?
No, but if you're saying she did it for those two, it probably should have captured whatever other car.
Okay, I agree. All right, so what's the license plate of the car that sped up behind Mr. Stillwell?
Well, I was going to continue. Like over the summer, I've been working in investigation quite extensively, looking for a very particular two cars in the city.
my
I probably have
gosh.
searched every
We don't
LPR in
care.
the city by make and model. And at night, you may put white Nissan, you may put white this, white that, and I'm getting back white
We don't
Tesla.
care.
When I look at the license plate and pull up the results, they're not correct.
Okay, and I appreciate that anecdotal story about what you've been doing this summer, but the fact is, that night,
Thank you, Max.
make and model was used to reveal the license plate of the Ford Fusion and the white Audi.
Right, my anecdote.
And it was nighttime on March 14th, correct?
Right, but depending on what LPRs those cars had hit, that location on Windsor right there, I don't know if there's one right there that would have caught it clear enough.
Okay, well, what LPRs did the car that sped up behind Mr. Stillwell that has not been tested for gunshot residue, what LPRs did that hit?
You'd have to ask Detective Hogan.
Wow. What's the point?
You keep saying ask Detective Hogan. One minute you're on the side of Windsor Street trying to find homeless people as part of this case.
Correct.
And the next minute you don't know anything about the case and it's Detective Hogan.
That's not what I said.
Okay. Well, I want to know, do you know if any LPRs were run on the make and model of any cars besides the white Audi, the Ford Fusion, and a red Versa? Do you know if any other LPRs were run or even attempted to be run?
First, I wasn't in charge of running the LPRs for the case,
Okay.
and if they were running it by make and model, that maybe they saw, if you have a make and model, it's much easier than just say not having one that you're looking for.
Okay. You talked about the phone conversation between Mr. Stillwell and Mr. Garlington about he never told Mr. Garlington, I don't know why I'm being arrested or something to that effect, or I don't
Correct.
understand. Okay. When people are arrested, you've arrested people before, right?
Correct.
Okay. And you typically tell them what the charges are. You give them that courtesy.
Yes, of course.
And you tell them what you're arresting them for.
Of course.
Okay. They don't have to agree with you, but you do inform them of it.
Correct.
Okay. So, are you saying that Mr. Garlington is the first person that Mr. Stillwell would have talked to after being arrested on that jail call or that phone conversation? Is that what you're saying?
No, he'd been in custody for a minute at that point.
Okay. And you would agree that there's probably been significant ability for the people that arrested him, other people involved with the case, to inform him what his charges are and generally what he's accused of?
I don't think that's what Ms. Hilton meant. That's not how I took the question for me.
Okay, cool.
So now she knows what Ms. Hilton means.
We pulled out this mapping information for the call on March 15th at 2 a.m.
Correct.
And it showed that, remember that radius? And
Correct.
it was Mechanicsville.
Correct.
Mechanicsville is, in fact, in the city of Atlanta, correct?
Correct.
It's in the city.
Correct.
All right. And finally, just one other thing I wanted to ask you about. Miss Knight, could you do me a huge favor? I think it's
That goes to the riding in the
publish?
city. That comment on the phone. Well, she didn't even know if it was city or scene, and she changed her mind. Insane.
Okay. This is 471 VV, and that is a picture of Mr. Nichols, correct?
Correct.
And on it says, on the picture on the right says, "What you saying? I run with cold-blooded killers, bloody killers."
Correct.
Okay. Now, I'm not an Instagram person.
Okay.
I'm not an Instagram person.
Those words, are those words that Mr. Nichols typed into this photo?
No, I stated that yesterday.
Okay. Well, we're going to go through the whole process today.
Okay.
So these words are when you pick a song such as Young Boy Never Broke Again, Villain, and someone clicks on the post, the music plays, correct?
Yes.
Okay, and as the music plays, lyrics come up.
Correct. You select a portion of the song that you would like to play.
Well, that's not entirely true. Instagram suggests a portion.
It's like between a 10 and 30-second portion.
Yeah, and
That
Instagram suggests.
you can agree with it or you can modify it.
Right, but Instagram suggests.
Correct.
Okay, so if I'm posting something and I want Young Boy Never Broke Again, Villain, I'm going to post, I'm going to say that's the song I want, and Instagram makes a suggestion.
Correct.
Okay. And now I want to
get her, Max.
Go to the video. Miss Knight, can you help me out with the VVA? Thank you, Miss Knight. 471 VVA.
Yesterday afternoon.
And Miss Knight's about to publish it. What I would like to do, and I know we've seen it already, but if you would indulge me, tell me when the screenshot that you took and provided in Discovery for 471 VV, tell me when that comes up.
I've been here to it all. I won't fuck with you often.
Yeah, I appreciate you, Rose.
I done came back from the desk, wipe off the leaves. I don't want any of these, let's move off the street. I fucked her the first night and then I never called again. Next time I was out to see me, I was around with a friend.
I was gonna have my page private, but you know what, man? I don't give a fuck. But y'all pussy. Don't even come from no fake page. Come from your real page. I don't give no fuck, man. Come on, man. It ain't private. It ain't private.
We're waiting.
I'm a bloody man, I don't feel shame for all them niggas dying. Holding on to my name when they claiming. Through the night I'm crying. These bitches lying, let's face the fact. Them bullets flying, let's talk about that. Can grab my strap, bye shot. I feel the pain of the end. When I did my time, I ain't feeling nothing, it was fun.
And this is what they want me to do on Steady Heights. I might die. Never getting on another fucking roller coaster day in my life.
Oh, you talking about? I don't want to talk. Won't speak on that, I'm too official. I heard your niggas niggas let them choppers off. Strictly about beef. I go to war with any nigga. I heard them say that they won't smoke with us. Ain't got no better nigga, ain't gon' fuck with us. So what you saying is up. I step on any nigga.
Name a block ain't hit, name a hoe ain't hit. Name a nigga don't try this shit to survive this shit. Every nigga don't try this shit, don't die this shit.
I can't tell you, might have gone too fast. I'm not sure.
Okay, could you go to 140 and just 138? Okay, right there, and just start playing again.
Won't talk, won't speak on that, I'm too official. I heard your niggas let them choppers off. Strictly about beef. I go to war with any nigga. I heard them say that they won't smoke with us. Ain't got no better nigga, ain't gon' fuck with us. So what you saying?
So, Miss Knight, if you could just rewind it, and it's very brief, about 1 second. A little bit further. I appreciate it.
Yeah. She's struggling.
Viverito, when you saw this story by Mr. Nichols, you had to scour this story to find the spot on this post where it had those lyrics, didn't you?
Well, no, I turned over in Discovery the video in its entirety because I felt all of it was pretty damaging and consistent with the case. But it's my understanding that we had to condense the social media, so that was the screenshot that was turned over in lieu of the video.
I'm going to ask that question again. To get that screenshot, you had to parse this to a millisecond to get those words up on the screen.
Or I just took a screenshot, and it happened to be that one, and we kept it.
Oh, it just happened to be that one.
There are other things that probably would have been better to keep.
Okay.
That weren't kept.
So, so you just happened to screenshot. Now, you would agree that in this video, there's Mr. Nichols, and these lyrics are being shown on the screen as music is being played.
Yes.
And you would agree that many of the lyrics, as the song is being played, are up on the screen and easy to read.
Correct.
Okay. Right before the lyrics become easy to read, there is a split second, a millisecond, that has those lyrics in that picture. 471 VV, isn't that correct?
Correct.
Yes.
You don't even know if those lyrics were the ones. First of all, you don't know if it was just suggested by Instagram or actually chosen by Mr. Nichols.
Correct.
Right?
The song was chosen by Mr. Nichols.
Of course, the song. Okay. I'm talking about the lyrics. You don't know if it was the Instagram choosing these lyrics because these are the most popular ones in the song, and they make a suggestion.
No, but based on the rest of the videos on the post, the theme is murder, bullets, guns, things like that.
That's not what he asked, lady.
So, again, and you don't even know when it's on for that millisecond. Just supposing, hypothetically, if Mr. Nichols did choose the lyrics, you don't even know if that was Instagram just had the last lyrics up and then was getting to the lyrics he chose, which are shown clearly, or if it's something that Instagram just chose. Mm-hmm. You don't know.
I don't, but he can preview the post before it posts to his account.
Okay. So you have absolutely no evidence that Mr. Nichols intentionally chose those lyrics.
Which is why I included the video in its entirety with other posts about murder and shooting.
And in preparation of this case, you scoured this video and paused it at that exact millisecond when it had those lyrics.
Did not. I took a screenshot.
Okay, took a screenshot. I'm sorry. At that exact millisecond where it had those lyrics that are in 471 video.
I probably took several, trying to catch all the lyrics, and that was probably when we had to condense evidence. That's when it was chosen.
How many different screenshots did you take?
I have no idea.
Well,
We're talking
can you
about.
just tell me from your report.
I can't. You can look at my folder that was served to Discovery and tell me.
Okay. All right, thank you.
You're welcome.
God dang. Boy, she's...
Is Weinstein anything? Okay.
Wow. Bad, man. Do y'all think Max made a good point there? It's embarrassing on her part, though. Doug Weinstein was cooking yesterday. Let's see if he's got more for us.
Good afternoon, Investigator Viverito.
He's been cooking all week, really.
So you mentioned that Mr. Kendrick's phone was seized at the time that he was arrested on May 9th, 2022, correct?
It was.
And his phone was extracted.
It was.
Did you review that extraction?
I did.
And if you reviewed that extraction, did you see that he had been spending several months in LA and had only returned to Atlanta within a day or two of the day he was arrested?
I did.
Did you also see other location data within that phone?
Absolutely.
Okay. And in that location data, again, he'd been spending the bulk of his time in California, correct?
Correct.
All right. Did you look through all the photographs on that phone?
I looked through a good bit of them, yes.
The two photographs that were shown in court this afternoon, are those the only two photographs of interest that you believe were in the phone?
No, there was probably a few.
Okay. Did you find any evidence on that phone that Mr. Kendrick was in possession of any firearms?
No.
Okay. Let's briefly return to the Richard Mill watch.
Yes, sure. Sure.
I understand the eye roll. During the seizure that day,
that night, she knows what happened with that watch.
and I'm looking at a property report.
Sure.
During the seizure that day, you, and when I say you, I mean APD, can I say under your supervision, is that accurate?
I didn't work for APD at that time, so I
Well,
couldn't.
Okay, then let's just say APD. APD seized. APD seized
might be
a necklace and a pendant from a bedroom, correct?
I guess I'd have to look at the report. I don't have it in front of me.
Okay, well, you were involved in this. They seized a blue box of jewelry, correct?
Correct, in a red box.
And a red box of jewelry. They seized jewelry that was on Martinez Arnold.
I believe so.
They seized a Chevy Corvette,
Yes.
a Dodge Durango,
Yes.
a Mercedes-Benz AMG,
Yes.
A Mercedes-Benz GLS class,
Yes.
a Porsche 911,
Yes.
a Jeep Grand Cherokee,
Yes.
a pink Lamborghini,
Yes.
another Mercedes-Benz aluminum silver,
Yes.
about jewelry that was located in a Mercedes AMG.
Yes.
And they even seized a ring found on Jeffrey Williams' hand, correct?
I'd have to see which one was on his hand. I didn't have any contact with Mr. Williams when he was arrested.
Okay. So despite seizing all of that, you left behind the Richard Mill watch, pink with a white ceramic case?
Again, Mr. Weinstein, as it's being inventoried, the jewelry is being looked at. I use photographed. The jewelry is being put on the thing, if you watch the video, and it's placed on the shelf, and nobody messes with it again.
So was that a yes?
Yes.
Okay, thank you. I have no further questions.
Thank you.
All right. Thank you,
snatched that
Detective. You are
Thank you, Your Honor.
excused.
All right, there it is.
any
Detective
more
Big
witnesses?
Burrito.
I know, but before we do, we just need to, can we have about 5 minutes?
All right, y'all.
To make sure that everything's in evidence, sure.
She knows what happened
We'll
with
take
that
a
watch.
short break.
There's no way you just take that watch and you set it up there. You can look at it and tell. Oh my gosh. Let me see. Let's Judge Whitaker said they're gonna take lunch. There's really nothing else that happens here, so Amy said you should show her pic. Oh, which one, Amy? There's some pics of her I could show. I don't want to show those, not on this channel. I'll maybe show this one. Here we go. Y'all can see this one. There she is. There's Big Burrito. I'm not gonna show the other one. No, Amy's up here instigating. I am not showing that one. Diesel said posted her nude. No, I mean, but yeah. There's anyway, we'll leave it at that. All right, thank y'all again for the support. Big shout out to the sponsors of today's show, Amy, Amber, and my guy, Dr. EJ. Thank you to everyone who I'm not showing the picture. Stop it. We're going to be back tomorrow at 9:30 a.m. Eastern Standard Time. Might be a little bit earlier depending on what happens this afternoon, but it should be right at 9:30. Y'all make sure you subscribe, hit the notification bell, like the video on your way out. And tonight, 8 p.m. Eastern Standard Time, right here on the Classy Beats YouTube channel, we have another show for you. It is the Song of the Night Live. So if you're interested in some independent music from some of the artists in the community, make sure you tap into that show. Looking forward to seeing y'all there. Thank you to everybody again who supported. I'm not sending it to your email, Rice Street.
Hey, yo.
Just go on X. You'll be able to find it. Y'all know what to do. Keep growing, keep pushing, keep it classy. We gone. Peace. Wild. Thank you, Starfly.